I told that don't give fresh matters before. No, I know. That's why I'm saying that I never meant that. I just said all these left out matters will be there, and thereafter only few fresh matters. Anyhow, yes, once it has come. Yes, who is in one?
Item 1.
Who is appearing? Who is the advocate?
No, nothing. Item number 1.
You mentioned the matter.
Yes.
Mona Lisa Sahu, K. Roth. Yes. None appears in support of the
Number 2.
Finally, it is a matter, but the petitioner has challenged the decision-making process of the tender committee by annexure 3. In similar matter, minors have already issued notice, and the matter has been reached to 23rd of the October.
same. Let it be tagged with this matter.
But the opinion number 5 has
Ma'am, I'm appealing for opinion number 5.
Come, name will be recorded.
It's there, my friend.
Yes.
Item number 3.
We have been agreeing for that. You know, the improvement order on annexure 8. RIG South of an order passed by this honorable court in WPC number 790/2022, wherein the petitioner has prayed for extension of lease period for 1 year. But by the improvement order, the collector had rejected, saying that Project I have a grant to pay 72 annexure 8.
76 anyhow. There's an order of 12th August 24.
Well, in that petition, the order was disposed of the application of
Only to consider representation. Then
within 3 months. But that order was annexure 7, page 67, 22/3/2022. By that time, the honorable court directed to dispose of the transaction within 3 months. But the collector disposed of it in 2024. And in that order, annexure 8 will also kindly turn to page 72. I have, towards the last part of the order, I have carefully gone through the Rule 8 of OMMC Rule 2016, which clarified for granting period for which the prospective license from mining lease and quarry lease for the specified
not included in the minor mineral rules.
and whereas sand is not included under the specified minor mineral rules. For the first time, the collector has observed this. But my application and direction of this honorable court was to consider the period of extension in view of Rule 8(4) of OMMC Rule. That is the only point to be considered by the collector.
Yes.
But it was also not now empowered, I think.
Your Lordship may kindly see Rules 8. Rule 8. It only refers to this specified mineral.
Sorry.
I'm just asking a question. The sand has been the domain of mines department after 22.
After 22.
22.
Yes.
So the collectors has passed in 24.
Yes.
Is he competent?
There was a direction to consider by this honorable.
So that does not confer a jurisdiction if the statute does not confer a jurisdiction. Can by a order of the court a jurisdiction be conferred? I'm asking.
But he was a lessee prior.
Whatever be the reason, but that power has been taken away. The new authority has come. Then he should have referred the matter to him to decide.
For the order of the court in 2022. By then,
There was no amendment.
There's no amendment.
So But he has not taken that plea.
Anyway, let us not.
But usually
Now, also we cannot direct the collector to reconsider or whatever.
Yes.
Then what is your submission?
My
and it was on concession. His order, which was passed in the earlier writ petition, was on concession.
not.
Paragraph 5. What are you talking? Look at the first sentence of paragraph 5 of order, earlier order, annexure 7.
68.
Force of hearing
Please, paragraph 5.
as regard to legal counsel for the party.
No, not as regard.
As agreed.
Yes,
As
by the council for the parties. That means you also. Is on concession.
Yes. Some concession. Some concession.
What?
As agreed by the land council for the parties.
So what do you use the expression? Some concession.
No, it is on concession.
Ah,
That is what I am saying.
Yes.
It was on concession. But however, if you logically look at,
But whatever he does not come, at that point of time, 8.4 was there. Odisha Minor Mineral Concession Rules of 2016.
my respectable submission, that provision 8, rule 8 applies to specified minerals.
Oh,
And-
understand, sir.
Yes.
There was some, since both of you agreed, so the court has not applied its mind on that and
Right.
then directed. But what is the correct provision has to be understood.
Yes.
So it is not that the sand is outside the purview of the Odisha Minor Mineral Concession Rules 2016.
Yes.
It is outside or within?
No, it is within.
So you have to apply the proper, the provision of law.
Proper provision, what the collector says, under rule 64, the state government is the competent authority to relax the conditions of the rule. Now, the term of lease was for 5 years. He wants extension of 1 year. So that extension, that is
It's
not,
permissible under the law.
no,
So
that is not permissible. Only that can be done provided the state government relax the condition of the rule and grant it. But however, the rule 8 does not apply.
where is the power to get have the extension?
Since the state machinery fails in their duty to protect the
Where is the provision? If they fail to discharge their duties, suppose, then there must be a provision which is applicable. Where is the provision?
Therefore, after complying all the formalities.
What are the formalities? There
That
should
is-
be a power to extend.
That
And then the formalities are provided. Show us.
exactly the word extension is not there, but rule.
What is the
provision?
provision? Show us.
Rule 8, Your Lordship.
Rule?
Rule 8.
8.
Rule 8. That specifies for the period.
Just 1 minute. Just 1 minute. Easy. It is a specified minor mineral.
No, sand is not specified.
Then how rule 8 applies?
That is the only rule wherein the period is.
But that is applicable in case of a.
Kindly show us what mineral is posing a question, whether that is a specified mineral or not. Specified mineral or not. That shows, because first sentence of rule 8 that says this is applicable to specified minor. Whether that is there is any specified minor mineral comprehending sand. Please show.
No, that
Please show.
Before that, you also can allow me to.
Please show that first. My lord is posing a question. First answer that, sir.
No, sand is specified minor mineral. Sand is specified minor mineral.
Specified minor minerals. Can you show me from the serial schedule?
What is specified minor mineral, sir? It is defined.
2AA.
No, it is
Yes.
defined. It is defined
That's right.
2AA.
Huh.
I was looking at only except the minor mineral listed in
All the
serial number
minor
2 of Schedule 3. Where is the Schedule 3? I'm just
Page
trying to.
115.
Huh?
115, if
Schedule
I am
three.
carrying the same book, that is page 115.
Yes, Schedule 3.
Here the collector has mentioned the wrong schedule. Schedule 2, the collector mentioned, but it is wrong. Schedule 3. Ordinary clay, sleet, rhematite, ordinary sand, other than used for industrial and prescribed purpose.
Ordinary sand is included in.
Yes, other than the minor mineral listed at serial number 2 of Schedule 3. Then that means the sand is taken out. If you say that it is ordinary sand, then it is taken out. Is it this sand is used for industrial and prescribed purposes?
No, there is no specification in their agreement they have executed between the.
So it's an ordinary sand. If it is ordinary sand, then it does not come under serial number 2.
Kindly see clause AA of
Yes, sir.
rule 2.
Yes, sir. So I see.
So if it is in serial number 2, then you are not coming under the specified minor minerals.
But my submission, respective submission would be Lordship, at such a related stage, when there are 2 or 3 occasions.
Whatever be the occasion, sir, if there is an order which apparently is in conflict with the statutory provision, can that order be insisted upon? I am just asking you this question. I am conscious when an order is passed by a court having lack of inherent jurisdiction, the Supreme Court consistent view is a nullity. If the order is a nullity, then will that order be directed to be implemented?
But at the time of execution of the deed, after completion of all the formalities, at the time of execution of the deed between the parties, at that time the authority could have said that the sand is not included in his.
Now, why they will say, sir, you are. Sir, there is no bar that the lease deed for sand quarry cannot be executed. Is there any bar? No bar. They can execute the lease deed for sand quarry. If they have executed the lease for sand quarry, now provision is extension. Whether it can be extended.
So this is the only rule.
You are talking about Rule 8. Rule 8 is applicable to specified minor mineral.
There is no other specific rule regarding the.
That means that there is no provision for extension or renewal of the lease. If there is no provision in the statute for renewal and extension, can a court pass an order, issue a mandamus upon the authority to act in a derogation or in defiance of a law?
Yes, Your Lordship. You
Can.
Your Lordship has sufficient power to direct since.
Everything.
No.
Even contrary to law.
No.
Can be part. I don't know.
In this particular case, since the authorities have failed to discharge their duty to protect the.
Sir, I understand. What is the protection? Sir, you want an extension of time. Maybe there are multiple reasons. Let us see that they were absolutely in default of their complying their obligation under the lease deed. Let us see. They have not honored the terms and conditions. Does it mean that you are entitled to a extension or renewal if there is no provision in the statute? You can claim otherwise. Make a claim.
Yep.
But extension and renewal is the main issue.
Your Lordship, kindly turn to Annex 3.
Yes, what is that?
The inquiry report submitted by the authorities, the inquiry reports, in view of the direction in the PIL, the opposite party now run the secretary, Revenue Disaster Management formed a committee to see that whether there is a illegal mining or there is any authorities.
I understand. So what is this? You are not doing any illegal mining. Let us go.
Yes, Lord.
Let us go to that extent. How it creates a right in you.
No, since the lessee has not done any illegal mining and he is protested by the victim, and the authorities said that yes, they have admitted that there is no illegal mining, and due to the obstruction of the authorities and pendency of the PIL, the lessee could not operate the.
I understand, sir, that may be a good ground for something else. Can it be a ground for extension and renewal? I am asking. whether the court can pass an order. If the lease deed contains a clause of extension or renewal, I can understand. If the statute contains any provision for renewal and extension, I can understand. But in absence of both, can the court of its own do it? I'm asking this very legal question. Show us the power, show us the judgment. We are with you.
Lordship,
Show us
Lordship, take up after vacation.
whatever you think, you ponder upon the things, but we do not. And also bring Mr. Das, there are one or two judgments I am aware that even a court cannot direct a particular court or the authority to decide a particular thing when they do not have the jurisdiction or the powers. The apex court judgment are there. It says that cannot.
Rule 64 requests the government to consider,
Yes,
relax the conditions.
yes.
Otherwise,
That is what the collector has said.
even if government cannot go beyond the rules because it is not specified.
After 5 years, of the lease period,
Yes.
if it
So proviso says minimum period is 5 years.
years.
That is lapsed. You are seeking for extension.
So-
Whether extension in law
Extension
can be
of 1 year.
permitted. This is the
Extension of
question
1
we
year.
have to decide.
extension for 1 year, within that 5 years, since the government was 5 years and I was protected, I was prevented for 1 year, therefore I applied for extension of 1 year of that lease period.
Yes.
At the request of
Yes.
Sir.
When you can get those line of judgments?
After vacation or
Anytime, tell me.
13th.
13th. But show us the law. If you show the law, we are with you. Yes. Next.
Item number 4.
Then after vacation, madam, give room to the others. They are mentioning. No, madam, you mentioned the matter or citing an urgency then. Yes, after vacation.
Item number 5. Item 5.
Yesterday this matter was there, when I come to annexure A.
Yes, for eviction.
In spite of this letter for eviction, since the police did not cooperate, so eviction could not be.
Oh, yes, yes. This is the matter.
It's a letter from CDA to the petitioner informing that due to non-deployment of police, it could not.
What is your instruction? You are representing the police also. To discuss. No. CMC, अच्छा CMC, Deputy Commissioner, CMC, Nodal Officer. Oh, it has not gone to them, actually. Tiki, it has not gone to them. Oh, the answer, I think this letter of 11/4/2025 was definitely not addressed to the DSP or a police. We are conscious it has not been addressed, but we just wanted to have a clarification from the content of that letter that they said that you are not, or the police is not cooperating. Whether any approach earlier was made,
No, Miller, no application.
nothing has been said here.
They have committed a mistake, but in the past phase, that people.
Look at it.
Yes, Miller, I am confident.
Where?
Miller, in the past phase, Miller, the italic person, that question was put to them. They have written that this letter at case 38, they
Mr. Tripathi, you are an advocate.
telephonically.
You are an advocate. You know when your authority has given an answer after italics. Have you not applied your mind on that?
I have applied mine.
Nothing you have applied. Then what you are saying? They have said. Police. But prior to this, there must be some communication.
After receiving this letter, I telephonically contacted them for clarification, and they said prior to this, they have not received anything.
Mr. Mudil, can you ask Mr. Dayananda Mahapatra? He appears for CDA or any council of CDA, appearing for CDA, and Mr. Devashish Naik, I think, for Cuttack Municipal Corporation. Can you please intimate?
See, this is not an adversarial litigation.
No, we are not
Sir,
saying
you are not understanding where what we find. If this letter is issued, that means there is an aspersion put on the role of the police administrator, and that shows that they are showing their lackadaisical attitude in extending all this thing. We can't shut our eyes to that realities. We wanted a clarification. Now the police has come, though written instruction is not really a reflection of the true and correct facts. But what he says that subsequently I had a telephonic discussion, and they say that they were never approached by the CMC.
By the CDA.
By CDA, never approached for rendering police assistance.
So I'm sorry.
Now the CDA must come and say that whether they have approached. If their stand appears to be factually incorrect, then we have to. Then you can't treat the court for a ride and say something which is absolutely false.
Then I'll serve a copy on.
So that is why my brother suggested that if you can, then bring him.
no, just intimate him.
Let's not
Intimate
kind
both the council, so that
Bring
they
them,
can
bring them,
say whether
bring them.
they can appear or not.
Yes,
Or
bring them.
if they want, we will issue notice.
Then, so far as Mr. Mahapatra senior counsel is
No,
concerned.
MR Pradhan must be there.
Yes,
He can take instruction from his senior and come back.
yes.
Both. For CMC also and for
Manasram
CDA.
Pradhan usually assists him.
Jnanaranjan Mahapatra is also there.
Huh?
Jnanaranjan Mahapatra is also.
Any
Both for CMC and CDA.
Devashish Naik, Mr. Devashish Naik usually appears for CMC
Yes.
or any other council you know. Just
Bring him.
Kindly pass over.
just ask
Yes.
whether they can appear in this case so that necessary instructions.
Pass over for the timing.
Item 6.
That was yesterday to worship. Now, the matter to go to the single bench and because that is contribution.
It can't be. It cannot remain here because it relates to any of the penal act.
That is enough. that I have gone through the judgment.
Ramakrishna Prabhuji.
That judgment. But one thing here in this case, what has happened? There was the
Legal question of law cannot be decided by a single bench. What are you talking? That single bench is not competent to decide a legal question. You were going yesterday. Very.
It's just I am bringing to lawsuit kind notice. Plus a proceeding which should have initiated at the post conviction stage, that has been initiated
No,
at
no.
the conviction stage.
It is in relation to this. So it has to go to the single bench. So after hearing the, after hearing the respect. Lacking inherent jurisdiction, can he pass a single order? No, it will be listed before the single bench tomorrow.
Yes.
By judicial order.
That.
Item number 7.
Sorry, I could not get time.
Yes.
I will take care of. I will take care of.
May I suggest? Instead of governing your Lakshmi anymore, Lakshmi may conveniently take up the matter sometime after petition.
No, that is what we are proposing and we are in the midst, brother, I just stated something yesterday, I could not complete. Been imposed on us, that is the whole.
Not your Lakshmi, so I have got no administrative responsibility.
No, not administrative, there are.
So let it be sometime after vacation.
And it is half dictation has been done.
But today also.
Yes, yesterday I wanted to complete it, but.
Today also, otherwise it's a last working day for me. Tomorrow I am not there.
Is after vacation.
After vacation, only one small prayer. As undertaken by HPCL Council, let them keep it on hold.
Keep it on hold. We are keeping this matter on 9th.
Ninth. So great thing.
Item number 8.
But in this case, if you're also.
Why you want an advisory is simply a recommendation, an advice.
That's exactly, that's the privacy of every individual, not to disclose so far as the income tax details are concerned, because the income tax details are not to be disclosed to anybody.
Is a privileged document.
Sir?
Is a privileged document.
And that can only be disclosed if an application is in 138 filed before the income tax department who can grant a permission to look into that. But here I have given annexure 1 that the Control Auditor General's notification and the 2, so far as the Reserve Bank is concerned, they also invite similar applications to be impaneled with chartered accountant firms. They have not wanted any income tax details. Only the firm's return has been asked that we are ready to give. But individual partners That is something it should not have been asked. As a statutory body without any authority, they are seeking for disclosure of those things.
Who is seeking?
My point, Madam.
Who is seeking?
If you also looks at Annexure 3, page 52, Madam.
Professional Development Committee,
Yes,
the Institute of Chartered Accountants.
it's a statutory body, Madam.
Yes,
As per the regulation of the Chartered Accountant Act,
yes,
under which the regulations are
correct, correct,
they have got the duty to see the chartered accountants
correct.
are developed, empaneled, and all those things. This empanelment, but what are the procedure for making an application to be empaneled? They themselves create it.
Hmm.
So that creation is contrary to that clause 9. If you are see clause 9, I'm only agreed on that clause 9. If you turns to page 56.
Yes,
It says the financial documents have to be uploaded by the applicants, that firm and continuing partners, that firms, I don't have any objection. Continuing partners failing with the application cannot be submitted. So there's a restriction not to make an application. Following the financial documents for financial year 23-24 are to be submitted. Partnership firm complete income, there is no dispute on it. Then let's looks at the next point. For partners, complete income tax return on Jackson format, income tax return acknowledging PDF, those are individuals. So individual partners need not file it, it is not required. The firm can give, because we are all partners of the firm. So that is the crux of the matter, in fact. If you also look at Annexure 1 and 2, there are a similar type of invitation given. But individuals, they cannot seek for it. Because that is disclosure of the previous document file. That's the only point, and that is also,
so I'm thinking in a different perspective.
Sir. To be the auditor.
So it's an option. You may or may not.
So if we do not, we will not be selected.
That's you are not seeking an opportunity. I am getting in a different
Perspective.
and considering its larger impact.
Right.
Yes. I don't want to when your first has undergone.
Well,
We say it is a privacy which is compromised.
then
There are many things which have to be
compromised.
which have to be borne in mind.
But if your lordship looks at,
I have no clue of whether you or but we both have.
by the recent judgment of the Supreme Court, that police have judgment, there it has been dealt with what is privacy and what are the things to be.
Understood, sir, but there is something. I'm thinking in that line because it will not be restricted only to
this.
It will be
Larger impact,
many parameters.
And I have given Annexure 1 and 2. They are similar. The RBI has given.
Privacy compromise. Some options whether you want or you do not want.
So there is only difficulty Lakshmi can see. I will be deprived. But we are all.
But the difficulty is choice. It's a choice or an option. Probably you get it where I am getting. You have to blame our system.
But it can't be choice, man.
I'm telling you, that's why it has to blame our system. Insisting for a disclosure of a privilege problem.
No, that is the only point.
That's a condition.
So
And that's the left. Somebody may say no. It will not. This is choice. There cannot be a compulsory.
So here the
So I was thinking that had it been that it is mandatory.
so it is mandatory. Man.
Let us see.
My lord, Narasimha Perudi Annexure 1, that is a document which is in respect to the policy of empowerment of the CS farms are concerned. In the very second line, it was very mentioned, Chartered Accountant firms and the limited liability LLPs in India at the last one full-time FCA partner or FCA sole proprietor can be applied for this. It is a purely a policy decision of the organization who will decide what is the system.
Are you representing the organization?
Well, for Union of India, I am here for Minister of Corporate Affairs. But unless until they are not instruction, I cannot appear. Well.
But they are a separate body. I think the Institute of Chartered Accountant of India is a separate body.
Separate body, it is a statutory body.
So the notice give.
Oh, yes, that's amazing.
Yes. 3 weeks. Well, not. Not. Yes.
Item 9.
For one will receive, for 2, 3, the Narasimha notice.
Yes. Yes.
Item number 9.
This is one request here also. My submission is that 26 is the last day.
If we are convinced, then it's all right. Otherwise, till date, we are not convinced actually.
Let them come.
May I please? If applications are illegal and arbitrary tender order has been passed against the opposite party number,
Arbitrary,
tender order has been passed.
arbitrary, illegal. And what? Third one?
As against the opposite party number 7,
No, you use 3 words. Arbitrary, illegal, and
malified manner.
malak. Yes.
And annex of opposite party number, I'm not feel well, my lord.
No, feel well. Don't worry. Feel well.
Opposite party number 7, my lord.
Yes.
My lord, annex 1 is the tender proposal notice, and he has engaged.
What are you doing? My brother has a very valid point
Yes, ma'am.
that you are not feeling well, but you are challenging the health department's decision here in the writ petition. They will be taking care of your health. Yes, sorry. There's a lighter moment. Don't worry.
My lord, kindly see page 65, annex 2.
Yes.
Sir, with reference to the subject cited above, TC initially viewed that as per the clause 2.6, actual proposal submitted by bidder shall remain valid 180 days after the date of bidding opening. Due to unable to circumstance, the tender has not been finalized. Hence, it has been decided to extend the validity of the offer submitted bidder another 240 days. Yes, madam. Thereafter, madam.
This was dated 21/11/24.
Yes, madam. After that, they have extended.
No, this 240 days they extended.
Extended.
Then
Thereafter, madam, Annexure 3, page 66.
Yes, sir.
That is 3/9/2025.
Correct.
And my lord, the first tender, which has been expired on 25th September, it has no more. Again, my lord, on 3/9/2025, he has been handed over the Nirmala Yojana, that is for engaged for and page 67, that is 1/10/2025. October 8th. This institution, my lord, becoming yes, and a blacklisted company.
Blacklisted.
Yes, it has been declared by Patna High Court as the central government.
Where?
Annexure 4, page 68.
Yes. When it is blacklisted.
Bimala Enterprises.
Yes. Oh, this is for
Just blacklist. 4/2/2000, I think 22.
This is the Bimla Enterprises.
Yes, this is the Bimala Enterprises.
Okay.
My lord.
Then
Yes, my lord.
where it is set?
And my lord,
Yes.
सभी राशि के भुगतान पर कालीकरण सूची ब्लैकलिस्ट
Where?
में that is my lord, it is not English translated, it is Hindi translated, but it has a blacklist. Paragraph 3. भूमि मुक्त कर दिया गया
No.
कालीकरण सूची.
Then they are possible. Yes.
And expect Gajapati district, other district and fair and transparent manner, they have issued tender manner. But in this case, he has neither
No. Sir.
Yes, madam.
He was already, I think the blacklisting order has been quashed by the High Court.
Yes, madam. The second
It
paragraph.
is quashed by the High Court.
Yes. Blacklist में मुक्त किया जाता है.
Correct.
Yes, madam. Madam, my respectful submission, kindly see Annexure 7, page 83. Regarding verification false fabricate documents submitted by some fraud agency in various tenders under Nirmala tender.
Page
83.
Yes.
And my lord, page 84. Issues experience certificate more than one agency for some service and some period. After scrutiny, the verified document, Nata Service Security Bhubaneswar, others are here. Again, we request you blacklisted those agencies whose documents are proven false and fabricated.
Correct.
Yes, my lord.
So only the Neta Security Services.
Yes, my lord.
And not Bimala.
Yes. Annexure 8, my lord. Cancellation of tender protest security service in Dhaka, other district, my lord. This district not. I am come from Gajapati. It is Dhaka not. And my lord, main vital things is Annexure 9, page 90. Annexure 9, page 90.
Correct, sir.
We are the 12 persons submitted the tender papers. Paper to Kajal.
Correct.
And it has not yet been opened, my lord. And it has not yet been
No. You say that it has been declared. You showed me that list.
Yes.
But now say it's not been opened. First, you took the plea that 240 days extension was done. And this contract has been awarded after 240 days.
Yes, man. It has been extended on 110 without inviting the tender, and he is also a blacklisted company.
No, it's not a blacklisted. Sorry, you can't say it's a blacklisted. High Court has already set aside the order. So you can't say.
My lord, he is not in Odisha. He is in Delhi, my lord.
So what?
Nothing.
Was there any restriction that only in Orissa? No, not in Delhi.
My lord, I have a legal right. I have submitted my tender. It has not yet been opened, my lord.
It is open.
Because after extend the period, they again extend in 110. After expiring the period, why?
Wanted to say I am unable.
When tender floated.
It has not yet been
Tender
paid.
floated, you submitted your bid.
Yes, madam.
Without opening it,
They have allotted it to this company.
extended the time period.
How can they allot? They must have opened the bid.
Let them say, let them.
Yes. Have you opened the bid?
Yes, my lord.
Yes.
In the bid.
This is what I feel. The language is like that.
What is his case? Your lordship may kindly see Annexure 6.
To be very frank, could not gather it till now.
But he was earlier awarded with the work order.
Correct.
He continued with the work order. Then an extension was granted to him.
Correct.
He was supposed to continue till 25th of September.
Yes.
Yes.
25th of September. Subject to condition that in between the tender process, the another tender
If it
process.
is processed, then he will not.
Yes.
Unless he is selected.
Unless he is selected. Now, your lordship may kindly see the Bimala against whom he is alleging.
He is the L1.
He is the L1.
Correct.
And he has been, the agreement has been executed to work from 1/10/2025.
After that.
After that, so petitioner is continuing till 39/2025. So the other work order pursuant to the fresh tender, civil
So you have opened the tender after the extension and awarded.
that specific instruction, that tender has been opened because if your lordship will look at Annexure 2, that bidders were given 240 days. The name of that Bimala Enterprises against whom he is alleging, the name is there. So thereafter the bid must have been opened because I'll have to
Let them file counter.
take
File an
action on
affidavit.
that.
File affidavit.
File affidavit.
I'll file.
No difficult. No entry model.
No case for entry order is made up.
Or I understand, sir. That's why I say no entry model. Let them file affidavit. 2 weeks after.
Ma'am. Item number 10.
Yes.
Item 10. Sir.
This one is for the construction of a railway state is a particular place. Now,
Yes.
along with the petitioner, many bidders have bid for the projects. Under they opened they made the technical evaluation, page 171. Petitioner along with others were technically evaluated. Thereafter, they opened the price bid, and at page 186, Annexure 4, the petitioner stood as the lowest bidder.
He
Stood as the lowest bidder.
could not.
Petitioner stood as the lowest bidder.
You stood as the lowest bidder. Achha, then,
That's it. Annexure 4, page 186.
yes. I am at Annexure 4, 186.
If your lordship would see that table, that Kalinga combines, your lordship would see fifth column, top, page 186.
Oh, it is.
Three bidders. Kalinga combines.
Yeah.
Where do you get it?
So below the
Acha, Kalinga. Acha, correct.
yes, below the Kalinga combines, your lordship would see
Yes, whatever.
rank
Then-
L1.
Kalinga, Tripathi and Sri Balaji.
Yes.
Then,
Below Kalinga, your lordship would see interse rank L1. So his rate was evaluated to be the lowest. This was
below
the
Kalinga is L1. Yes.
Yes.
So,
This was in the month of April 2025.
true.
Thereafter, my lord, I have about in my rate application, I have approached the railways just to know about the status because I stood as the L1. So to which they replied, it's under process. Now, when my lord, page 192, when this process was continuing and I was also extending my bid validity because the bid validity was originally 20 days, so I have to extend. Now, on 10th of September 2025 minutes, Annexure 5, page 192, when I verified from their website, I found page 193. This very tender is 1, 2, 3, 4, 5, 6, 7. Seventh from the top. 193, seventh from the top. Lordship has got. The work name is Development of Nirgundi Goods. tender finalized.
Hmm.
So I rushed to them to know about the status because I was the L1. I have not been intimated anything about till that date. So how you finalize? In fact, I have on the very next page, I have annexed a letter. I immediately emailed to them. I personally made them to which
What is this word lapsed?
last date for bidding.
Okay. So what happened?
At page 195. On 12th of September, I have issued a letter to them. I emailed this.
Then what happened? Tell me
But they have not replied anything on
that.
They
Then
said, no, we have finalized the tender. L2 bidder has been awarded with the work.
where is that?
They have not issued.
So what is this?
So they have not issued. That's my case, my lord. I was the L1.
Who is for the railways?
I'm sorry for
We are appearing, man.
Yes, what is this? Have you awarded it to L2 when he is already declared L1?
First time I will take instruction, man.
Take instruction. Take instruction. Come after vacation.
Yes, man.
30.
Item 11.
Not to finalize the
What finalize? They will. If ultimately you win, you win. Don't worry.
By that time, if they issue the work order and they
Then nothing will happen. That's the risk. Any.
Then I will be prejudiced. They will take the plea. I have already started the work.
I also
You take notice on both.
Any action will be subject to results.
Don't worry. Come.
Item 11.
To the police, I will bring out my
Those documents that whether you have made a requisition to the police because there appears to be a
I will call it, sir. I will call it that. I will pay it. No.
after vacation plan. Take
You
this.
can also appear for CMs.
Yes, please also because
Copy and receipt.
yes, look at it.
See party references for cutoff bills for doctors.
They're
Not 14.
Absence of this journal is covered.
Thank you.
Item 15.
Difficult case,
difficult case.
because of the reasons, that out of confusion and due to the health condition of the petitioner, there has been a delay of 34 days in filing the appeal. So the confusion arose from the
What to do? Again, the big question arises.
But your lordship would see this, that it is not, in my humble submission, it's slightly different from the other cases which your lordship have seen. The lordship would kindly.
If you are within that particular outer cap, no problem. If you are beyond the outer cap, that's the issue. I wanted all the members of the bar to address us.
Your lordship have kept those matters on the 13th, but your lordship will kindly turn to page 51 of the impugned order. The impugned order begins at page 34, but I beseech your lordship to kindly turn to page 51.
51.
Where the difficulty arose and the confusion in the mind of the assessee. Maybe it's a typographical mistake or a printer's devil, but your lordship will kindly turn to page 51, paragraph 16. 5 lines from the top notes. Your lordship got it?
Hence, you are directed or
You are therefore directed to appear before the undersigned on or before 1/2/2025 in the office of the Deputy Commissioner of City GST Enforcement Unit, Sangapore in person or through authorized representative. If you fail to appear and furnish satisfactory reply on or before the scheduled date and time, the case will be decided as ex parte on the basis of the records available and on merits. Here, my lord, they give me a time till 1/2/2025, and the order is passed on 2nd of January 2025. So what the confusion arose, my lord, is whether this is a show cause or whether this is a final order. So, and coupled with it,
it was one in January 25.
the 2nd of January 2025 was the impugned order. But in the impugned order, my lord, they say that you appear on the 1st of
And then you are ordered to pay the required amount of penalty.
So, my lord, it's completely, my lord, what the SSC.
I understand, sir, everything, but that
True, my lord, but your lordship would see these are the
that
extra-
problem
I
is
bow down, Lord. I bow down.
persisting.
I bow down, Lord. And coupled with it, my lord, health conditions. And
I
with the-
understand, sir. Absolutely, it's a manifest.
I'm sorry, I could not get that order.
But-
A typical case. I'm sorry.
But that did not take into consideration that Supreme Court judgment.
Supreme Court judgment, I'll with greatest of respect, my lord.
Because it
Supreme
says
Court
that
judgment
if
is
the writ petition after the period of limitation expired in filing the appeal, if is not maintainable.
The Supreme
So
Court,
that is what is the problem with
in
us.
the Supreme Court judgment, my lord, it was not an era where portal communications were made. And
I
that was considered to
understand,
be
sir,
final.
whether
And your lordship knows about the various difficulties in the portal.
I fully appreciate. It's one of the good case where the interference is very much warranted, but
And in a recent judgment, and the recent judgment of the Honorable Calcutta High Court, due to the partner's ill health, 75 days.
oh, I understand, sir. The very good point is that when he has fixed a date for submission of the document on 1st February,
Then-
how can he pass an order in January?
Sir, Lord, will allow your lordship to allow me to go and appeal, Lord. Entertain the appeal on merits. Lord, that will be the
Then
signal.
what is the purpose of fixing a timeline limitation?
No, if this is the issue,
I am again saying, can it be?
Lord, if it is 1st of February 2020.
Very simple case. When the Limitation Act is introduced by the Parliament, for what purposes the Limitation Act? You may have a right, a wonderful right, legally enforceable right, inchoate right, indivisible right, everything is admitted. Can a relief be granted by the court after the period of
This is
limitation?
the Honorable Court of Justice. And justice
That must be within the four corners of law.
True, man.
So can a justice be done beholds the law?
And in justice coupled with equity. And here your lordship.
Equity be also within the four corners. Cannot defy the mandate of the law in equity. Article 142, the Supreme Court may, I do not know, we do not make, but High Court is.
Barring the delay, this would be enough for your lordship.
I understand, but it's still.
Your lordship would
What
see
to do, brother?
he's not
What is the whole
well
problem?
versed in law, or the niceties of law.
It is true. They can't say that you are ordered to pay.
He's building up the case like Salem. Salem case.
Salem, Bharat.
Yes, sir. Yes, sir.
I understand.
So hard.
But
I have also given the details of my illness, which I was suffering since March. And that is why, Lord, I couldn't even go to the office to clarify that whether this is a show cause or whether this is demand.
further order is passed.
The further order, my lord, is, I filed an appeal against this order. There was a 35 days delay.
Further order means ordered by this.
No, Lord. In this particular case, he says that this is the demand. At page 52, he says that the demand of penalty and fine is 12 lakhs amount.
Sir, probably you are not getting it.
I'm sorry.
You say that there is a reasonable apprehension created by this document in the mind of SSC, whether it is to be termed as a so-called notice or the final adjudication.
True.
Because you have said that in one place he says that you come and appear and produce the document by 1st of February. And in the conclusion part, he has already directed you to pay.
And that is on 1 month earlier, 2nd of January.
Now, whether it's a so-called or it's a final order.
Madam.
If it is a so-cause, then so-cause has to be issued prior to, it cannot be termed as an order.
Right.
Then you did not appear.
I did not because of my
You
illness.
did not appear for whatever the reason.
Madam.
I am asking, after this document,
There's no other
further document.
No, my lords.
In the form of an order is passed.
No, my lords. With great
That
respect, no.
treating this as a show cause notice,
Man.
not as a final.
Man, no,
I'm
no
asking
further
this,
orders.
no
No further orders. I file an appeal, my lords,
Against this.
against this.
And
And I stated in my delay condemnation that this is the reason. If the lordship would see, my lord, my specific. Not 161, no, could not be. My lord.
No, would not it be after even disposal of appeal?
161.
When there is a confusion that what it is, so it is error appointed to place of the record.
He was advised.
I'm just
Man,
thinking
true man,
aloud.
true man.
so it is very difficult for you.
Let me clarify. Your Lordship, subject to your Lordship satisfaction.
Nothing.
Order has been passed, Your Lordship, on that day. Your Lordship, let me clarify. Let me clarify, Your Lordship. Let me try to convince Your Lordship. Annexure to the DRC 07 has been started with effect from page 34. So this is the date of order on 1st February. Your Lordship,
Then why you fix the
Section
date
130,
appearance?
section-
I'm asking you why you fix the date
Section
of
130
appearance.
subsection 2 says it is the order, but in lieu of confiscation, the penalty in lieu of confiscation, Your Lordship, if you will not pay this much of amount within by dated so and so, your goods will be confiscated, Your Lordship. Section 130 clearly says that. 132, whenever confiscation of any goods conveyance is authorized by the Act, the officer adjudging it shall give to the owner of the goods an option to pay in lieu of
Don't go. Please read paragraph 60
Your
of
Lordship.
the order.
Your Lordship.
Don't justify without the records.
You have
And there
told
is
that,
not,
Your
it's not a
Lordship,
transport. No. It's a
not
Sir,
transport.
whatever be them.
Not
You have
directly.
sold out, you have
Yes.
sold out the goods worth rupees such and such
Your
without
Lordship.
issuing a tax invoices.
Your Lordship.
The reasons were discussed above.
Your Lordship.
For such contravention of provision of the GST Act, the goods under seizure are liable to confiscation
Your
under
Lordship.
section 130.
Your Lordship.
Where in the section 122 said, hence,
Your Lordship.
you are directed to show cause. You did not say seizure
Your Lordship.
or confiscation. Show cause on or before 1/2/2025 as to why the penalty and fine in respect of our above discrepancy shall not be payable by you in lieu of this confiscation.
Your Lordship.
You are therefore directed to appear.
Your Lordship.
First thing is, you said that why I should not impose a penalty or a fine in lieu of confiscation. Then you say, you are therefore directed to appear before the undersigned order before 1/2/2025 in the office seeking a GST enforcement unit in person or through authorized representative.
Your Lordship.
If you fail to appear
Your Lordship.
and furnish satisfactory reply,
Your Lordship.
on or before the scheduled date means 1/2/2025 and time, the case will be in future days decided as ex parte on the basis of the records available and on merit is that you will decide the matter after 1/2/2025 if they fail to appear on that day. And then in a conclusion, in the same document, you are hereby ordered to pay the required amount of penalty and fine as calculated, amounting to rupees such and such.
Your Lordship.
What does it mean? I am just asking you. You have invited him that why you should not be settled with the fine and the penalty in lieu of confiscation. If you do not appear and do not give a satisfactory reply, then an order will be also be passed. Then you should not have passed the order imposing penalty and fine. You should have passed an order, both confiscation, both penalty or fine after 1/2/2025. That's why I asked you a question, is there any further order after 1/2/2025 where you have said that since you did not appear, I am calculating it, the position would have been different. I am asking this question. You said there is no other order. This is the order which is passed. Can you pass the order?
Your Lordship, and after this DRC 07, he has filed the appeal.
Sir, why you have given a time? You could not have given a time. 1/2/2025 to appear.
Don't go for this. DRC 07, DRC 01,
Because the
come to
rule,
natural justice.
your lordship,
Come to the natural justice and the statutory provision.
here the original
Have you
notice,
taken up any action for this confiscation? No, I will ask them.
There should be an order subsequent date.
Yes, that's not
Subsequent to 1st February.
mere seizure will not empower you to confiscate automatically.
your lordship, the
But again,
scope,
I'm saying,
the initial, the initial.
judgment is staring at my face. Mr. Vishnu may have lot of, yes, conserve energy and wanted to exhaust it, but the difficulty lies to that.
And after 100,
I
after
also
page
wish to say that
130,
if you
after 107 order, after 107
The
order,
order is under check. Is it a so cause or it is a final?
no, let's see,
If
this,
it is a final order,
this has been challenged before appellate authority,
with out of
out of time. And on out of time, that has been
that is
accepted.
what we are stuck with.
So in these circumstances,
In
your
other
lordship,
circumstances, we have interfered, there is no difficulty. We know the outer cap has already been fixed.
your lordship,
But once a judgment, Claxocal judgment is cited,
your lordship,
which impedes the entertainability or maintainability, it says maintainability,
Mal,
not entertainability.
your lordship.
Then in that event, can he maintain the writ? That is the main issue. Fact,
Your lordship.
I believe he is very, very good on facts, no doubt. But
That is a stumbling block for me.
yes,
May I make a humble suggestion?
and I invited all the members of the bar to
May I make a very humble
assist
suggestion?
the court.
So letting
May I make
approach the tribunal, even no fee is
Tribunal,
required.
your lordship
No
would appreciate.
fee is required for filing.
If your lordship,
Sir,
There are no.
sir, then I'm giving it. If you go to the tribunal, then you will say that what is the subject matter of challenge before the tribunal is an order of the appellate
Yeah.
authority.
Your lordship.
An appellate authority order cannot be touched because the admittedly after the adjudication.
Your lordship.
So where you will go?
That time.
You can't blow hot and cold at the same time. If the alternative remedy is not efficacious, can he not, which is one of the ground for it, that there is no alternative efficacious remedy available to the minister. It's not efficacious. But Mr. Quorum, cross that line. Cross that.
I'll just make
You
a very,
may,
no,
you may have a good case on merit. You have said, but we will not. When we are exercising the jurisdiction, maybe you have the best case under the earth, but still the jurisdiction is the point.
But
where
if your
we have
lordship
to-
would appreciate, your lordship have heard me patiently. The show cause
I understood what
1 month earlier, the order is passed in January. They asked me to appear on 2nd of February.
whatever.
And that will be my lord in my humble submission.
Sir, you are really igniting the devastating fire. Sir, it is already a devastating fire.
So I'm already in.
It's not a spark where you are putting a fuel into it, igniting it to become a devastating fire. But still, question is
Before it turns into an inferno, my lords,
no,
I'd only pray,
it will
Lord,
not.
your lordship would be the firefighting,
Yes,
Lord.
it is.
Your lordship would do the firefighting through to 26.
No, sir.
Before it turns
It
into an
will not
inferno.
do. Even a fire tender will not be
But your lordship's
And,
26, Lord, your lordship's
no, not
26
that.
jurisdiction can be, Lord.
jurisdiction.
No, can be, Lord.
Plus, I invited the attention of all the members of the bar.
But those are, my lord, typical, that those are cases and cases, my lord.
Please come and assess under what circumstances, under what.
But I'll definitely revert back to your lordship. No, in the meantime, Lord, may I make a humble suggestion? In the meantime, your lordship may permit me to pay 10% of the penalty.
The difficulty.
No,
My understanding may be wrong, sir. But still, I am very firm on my understanding.
True, I bow down.
If the court finds that it lacks jurisdiction to entertain, the court should not pass any interview.
So there have been cases.
Should not pass an interview. That's my firm principle and understanding of law. I will not
That is one-
any order which is a nullity per se, because the court have no jurisdiction.
No,
We will not pass.
your lordship would appreciate, in many cases, in absence of the GST tribunal. Your lordship
It
has
varies
asked-
from an understanding of one man to another, but my understanding is this.
My lord, I'll just try to simplify the matter for your lordship's kind consideration. Your lordships have allowed many cases on payment of 10%.
Without noticing the Glaxo
No, 10%,
judgment,
no, I'm
it
not-
was all.
No, I'll address that.
A person should not remain ignorant throughout his life.
No, your
By
lordship.
passage of time, he is enlightened, then he should be very fair enough to embrace some or adopt some new things.
But here, my lord, in that juggernaut, my lords, tiny ants are also sacrificed. The juggernaut should roll, definitely, sir.
No,
But that discretion,
I know Juggernaut, but
the juggernaut should roll, but should not wipe out these
No.
poor SSEs, my lord. And your lordship, may I make a humble suggestion, my lords? My lord, submission, my lords. In absence of the GST tribunal, your lordship, I'll come back to your lordship on the 13th, but in the meantime, I'll pay 10% of the penalty as per the statute of section 112. Your lordship may stay the balance. I'll come back to your lordship on 13th, my lords. Because had I made a prayer, then in absence of the GST tribunal, your lordship would have kept my writ petition pending and allowed me to pay 10% of the penalty, my lords. So in that case, my lord, I'd only humbly pray, I'll pay 10% of the penalty, awaiting the...
but we will relegate you to the tribunal.
That the lordship would decide after 13.
No.
That the lordship would decide whether I have a good case on merits or not for the interim. Otherwise, there's a threat of attachment. Lordship would see the business.
That is.
Then this case,
You have to go.
then this case will be tagged in that batch.
Correct.
That batch, but as treated differently pending the 13th decision of a
You
lordship.
will tag it.
Your lordship, only
We don't.
But for the moment, my lord, it's a temporary relief, my lord.
You can't.
It's a temporary relief, but a lordship may treat this case differently.
You can't have a cake and eat it too.
I am neither having the cake nor I am able to eat, my lord.
even if it will be
No,
added in that batch, no 10% is also required.
Sir, this point, whatever. There is a remedy provided in the statute. He has a right to challenge the order of the appellate authority,
Your lordship,
whether it is dismissed on the ground of limitation or on merit.
your lordship, I
That
power.
right you cannot take
I
away.
can.
If that right is there,
Your lordship,
definitely why not?
your lordship.
But again, it's a double-edged sword. So that's why I just make him aware that where he lies or where he stands.
So I'm against the wall. I'm trying to fight with my back against the wall. But I'm reminded, my lord, if the lordship would appreciate
10%. What about 10%? Not really.
10% of the penalty.
Fine and penalty both.
No, the fine and penalty both. They have a
Yes,
levy
yes,
fine and
yes.
penalty both.
Your
And
lordship.
the lordship would appreciate he's dealing with threats. Lord, he's dealing with threats and swing
penalty is
needles.
120.
Your lordship would look at the nature of the business. Threats and swing needles. And your lordship must be aware at a place, remote place, how these milord are marketed and how difficult it is milord to make a both ends meet. Otherwise, it would not have the lord.
No, sir. Trade when you are, we do not know.
No, the lordship need not compare me with the other wholesalers of thread.
I know some.
Those are milord's big houses.
What big houses or small? These are red businesses.
Sewing threads.
Swing thread I am talking about.
And it's not a wholesale dealer of any
No,
reputed
not
brand.
wholesale. Anyhow, we are on live. We can't say anything.
No.
We know our restrictions and regulations. Yes, call.
Lord, may I just humbly pray, Lord?
10%.
10% the balance be stayed. Lord.
This is automatic stay.
No, 10% on penalty.
Of the penalty. No, because 112 by
Statute
the
doesn't permit.
no, the 75, the 2015,
Only tax.
no, the 2025 finance bill had it inserted a proviso. A proviso in 112, which says that 10% it was 10% of the penalty. In addition to 10% which you have paid in first degree. Sorry,
Amendment.
amendment 2020, it was inserted. 112, if the lordship would see. 112, it has been inserted.
We have old.
We have 20, but I have 2025, but it is not there.
No, lordship, that's by the finance bill 2025. So it should be fair enough not to state that I have to pay 20%. Lordship may kindly. And in the 107 subsection 6, that has also been added now. It has been reduced from 25% to 10%.
In 107.
107, it has been reduced from 25% to 10%. And by way of a proviso, in 112 by finance bill of 2025, they have chosen.
Item 17.
That's actually cancellation.
All.
Yes, Mr.
Item number.
First two item I am appearing.
And in the third item, it's again central GST and
Not yet covered entire Odisha till now. Not yet covered entire Odisha.
Yes, third we have seen.
Item 18.
Cancellation of RC.
Yes.
Item number 19.
Item 19 also is RC cancellation, Your Lordship.
Item number 20. Item 21.
My lord, RC cancellation of GST.
Yes. Give.
20 is not asking.
Yes.
20 is not asking also. Item 21, sir.
My lord, may I please, not see my lord. RC cancellation of GST.
Item 22.
RC cancel.
Item 23.
It has become infectious because I challenged the blocking of ECL, electronic credit rate. Now they have removed it, but it has been unblocked today morning itself at 11 o'clock.
Yeah, it has been unblocked.
So I make a partnership.
Unfortunate for us. Because this is perhaps first tax case we are moving.
Yes, madam.
First tax case. This moving is.
It is submitted by the council for the that the was faced with the institution already been repressed.
Item 24. Item 25.
25 is the 25 is appearing. Mr. Lokinaran sound.
Not present.
Yeah.
Item 26.
Who is appealing? Say that you are not responding. Yeah.
The similar process.
Yes, yeah. Yes.
Item 26.
Please, two issues are involved in the present execution. First, the clubbing of the period, and second is that while the show cause notice was issued, there was certain rectification that were needed to be carried out. While the show cause notice was issued, I filed a rectification application under section 161. Instead of dealing with the rectification application, the authority has been issuing to me personal hearing notices for adjudication notice election instead of disposing of the rectification application.
He has filed a petition for rectification. Yes, ma'am.
Yes, sir.
Suppose the later on it is rectified, then the orders will be absolutely a farcical society. Before proceeding to if the officials were arrived after the disposal of the rectification application, they will proceed for it.
After, in case of it.
They will continue with the present one. Because there's also an issue.
Yes, sir. Now,
The thing is, they will put that all that until your revisional or the rectification application is decided.
yes,
If the rectification comes, all out the consequences has to be taken into account. And that's why I say, if the circumstances were warranted with the continuance of the proceeding, then we continue. Not fresh.
the date is fixed to your lordship 7th of October.
We are saying that they will not proceed any further, we'll keep in affairs for the
Yes.
time being till the rectification application is decided.
Oh, next week.
Your senior is thinking about the consequences. What would happen?
Actually, if you not find permission, section 17 says, if I pay 30% within 30 days, because it will be deemed to, proceeding will deemed to concluded. I want to pay the money as per the rectified order. That is the.
So that's why I say in these circumstances, suppose your rectification application is
Dismissed.
that
Then cause of action available to
what that will continue. If it is allowed,
It's popular.
then you will have to pay the amount as per the rectification order that is under the law. If you pay, it will come to an end. If you pay, it will come to an end. You will go and record that you have already paid. You cannot proceed.
I believe reasonably that will never be rejected. Reason being, apparent payment.
Consideration in that proceeding. That
is what I mean.
Advocate of proceeding.
Yes.
Suppose you not pay kind. One example I will give. Supposing SCN is for 50 lakhs. I have paid 25 lakhs. My problem is, as your lordship knows, if 25 lakhs will be appropriated, then out of 25 lakhs, if I pay the balance, out 50 pay the balance bills, the proceeding will come to an end there and there.
I understand. Can we visualize the situation? That they have demanded 50 lakhs.
50 lakhs.
Now you have gone for a rectification of the order because according to you, certain amounts
have been paid, not taken
be adjusted and taken into account.
Apparently,
obviously, there will be a variance or the total amount has to be varied. And it be adjusted. So it may come to by that, it may come to that after adjustment.
Exactly.
From 50. If they rectify the order,
notice, not order, notice.
the notice and then say that whatever the reason is that we have reduced it. We have taken into account, this is the amount.
Yes.
If you pay the amount within a time, then they will not proceed. They will not proceed.
But unless there is a rectified notice is given, 30 days time now has expired.
Oh, that is what I'm saying, sir. If you pay the amount, whatever after the notice is given or after the order is given, pass, you can, if you pay the amount, the differential, then there is no occasion to initiate a proceeding matter under Section 70.
That was not the guidance.
You will bring that, but the situation is, if they reject your application for it, saying that you have not paid, no adjustment.
Then I have to go for appeal minutes because appeal is appeal order.
Then, if you do not go for an appeal, if they not proceed, will they not proceed on the basis of the notice?
Of course, yes.
Seeking
Rectification
application
don't have a confusion in the mind.
No. Rectification application intended to rectify the defective notice. Apparent notice is rectified as per 161 of GST Act laws. The error in the GST notice is rectified, can be rectified. So for that application is final. Whereas two options are available to me.
Sir, on rectification, this notice itself will not go. It can only be amended. That
Yes.
means
Correct,
the
correct.
original notice remains and further it will be proceeded with.
With 30 days
Taking into
time.
consideration your
Okay. 30 days time.
rectification.
Outcome of rectification cannot abridge the benefit granted under 78(7) of the Act. 78(7) says 74 subsection 8. Sub 74
I think my brother of a very celebrated observation of one of the yes.
Now the law is such. If statute, but a legislature doesn't want to
Definitely off-put it as an observation. The first line I am saying, second line I am not going to say. He says the more learned a person is, and then I stop. Second line.
After your lordship understand, we must stop. I don't want to proceed further. The implication I wanted to tell.
That is what I say. The second line, the honorable judge says something.
Correct. That's the most important thing for a lawyer to know. Where to stop, not where to start.
That must be portable course.
Yes. In the rectification. Proceeding. Yeah, what? Expose law.
Item 27. 27. Item 28.
Right, 20, challenging the adjudicated order under 734.
All the two items?
Yes, ma'am.
Any other there?
16.
Yes. Anybody who is available in the supplementary?
Yes.
Lordships,
Or should we start from the second half? So we have to go serially. It's appearing in item number.
I appear on item 1, your lordships.
Yes.
Yes, item number 1.
I
Item
appear,
126,307 of 2025.
Yes.
I appear on item 1, your lordships.
Yes.
Lordships, I'm challenging the jurisdiction of the officer.
You are challenging the
Jurisdiction of the officer in issuing the notice to me, your lordships, on 2 grounds. On 2 grounds, your lordships. The first ground.
It's under what problem?
Lordships, the deceased SSC's assessing officer, jurisdictional assessing officers at Chennai, your lordships.
Yes.
So the authority who had the right to issue this notice would be the Chennai officer, your lordships. And second thing, your lordships, that the PAN number of the deceased should have been quoted. They have quoted the PAN number of the legal head.
Of the
Legal head, they have quoted the PAN number, your lordships.
Yes. What do you say? How can it be?
This Bhavika Gandhi is the legal head of the deceased, and the PAN number belong to Roundkeller Division. And it's a PAN-based assessment is being done, so that the notice has been issued to Bhavika Gandhi. Let me take instructions in this way.
You'll have to, because this says that the proceeding has to be initiated in the PAN number of the deceased Bhavika.
It has been done on that.
So, but you are using the PAN number of the.
No, your lordship.
Oh, just reverse.
Reverse.
Oh, you are doing an assessment of a disease while using the PAN number of the heir.
Legal. After submitting the document, she has submitted the document.
No, how can it is? She is not.
She submitted the document. Let me take instruction.
Please take instruction of 2 weeks.
Lordships, there may be stay in this matter.
Don't proceed.
Item number 2, WPC
I would like your
2678.
lordship.
Non-constitution of the tribe.
Item number 3, 26893 of 2025 and that.
The first subitem, multiple years.
Traders.
Where, no, Siva Prasad Parida.
The mean item, not sub item.
3 subitem 1. Item number 3 subitem 1.
First one, 26893.
That is main item.
I'm sorry. Sometimes the hangover will not continue. I'm sorry. If we think of in a particular direction, will not comes out.
That's a very offensive statement.
I'm sorry.
That doesn't apply to.
I know. But sometimes you get habits and old age also.
Yes.
I'm sorry. I've made the necessary. The multiple years.
What about this?
Subitem 1 and 2, but these two items are also similar, multiple years.
Item 4, I am for the petitioner, your lordship, 73 for DF.
Your client.
Anytime changes.
73 for DF.
I'm sorry for the interruption. I'm grateful to my learned friend. The finance bill has also been assented to and an act has been formed.
10% he has to deposit 10%.
10%? No. So, the balance.
That is the finance side number.
Number Milord is 15. I'm sorry for the interruption. Yes. The bill has been noted.
The bill has been finance act 29th class.
Which is introduced in
Finance Act and Finance Act number
section 112 subsection
8 provision.
Subsection 8 provision. This has been inserted.
The proviso to section 12, subsection 8.
It has been inserted.
People are not allowing me to complete the sentence.
Yes. And the Finance Act with effect from 29 March 2021.
Finance. Sorry for not doing my homework properly.
Yes.
I'm sorry for not doing my homework properly. I was stuck up with the bit.
Actually, I'm sorry because I have already said that no pre-deposit is required. I'm thankful to my Lord Chief.
Your position, locational.
Malos. And especially during the pujas.
Almost scattered and it's
I stay in the place, Lord. No.
So today is Chaturthi. Today is Chaturthi.
You can start from Shashti.
But the function begins 1 week earlier. And in spite of orders of the Honorable Court, the DJ sets have not stopped. The decibel levels of
65, I believe.
65.
Then up maximum 10 years.
But they have stopped using DJs.
Must be.
But the percussion instruments which are using is much ahead, above 60.
Sir, at 10 p.m. At 10 p.m. it doesn't stop.
It doesn't stop.
It should be by after 10 million notes.
And Lord, even your glass window panes vibrate, Lord, with that sound. I'm sorry, Lord, sorry.
That I face the trouble.
Very difficult to get in and get out, Lord.
That is the regular feature there. It's not difficult.
Right. Of 2025.
The side is here.
Of 2025.
The side is here.
Entered appearance to
No, this is because we were following this matter before vacation, but before this is that file.
That is only three books will be taken up after vacation. I have five. I paid for the
Only 6
items.
915.
915 is.
Papers do not have a lot. We should begin.
Yes. Item 7.
Yes,
16. 16. Item 7.
My Lord, in item 7, I represent the petition of placement. This matter was, learned colleague had assisted this honorable court on Tuesday. This learned court asked us to look into 3 judgments on the question of limitation. In the meantime, I have gone through those judgments. And in my case, definitely the judgments are supporting me. One is this Sankara.
What is the matter about?
Sir, this matter is all about in 2014.
Why your requisition was dismissed?
Sir, that's
Your
a
explanation is?
Sir, what had happened? LIC policy holders housing.
Oh, this is the housing one.
Correct, sir. What had happened in 2014, by draw of lots, I was one of the allotting. Before registration could happen.
For the LIC.
Yes, sir.
Right.
Before registration should take place, before registration could take place, Department of Revenue and Disaster Management, they came out with a circular saying that no registration will happen unless the ROR is with LIC. With that background, this was stopped. Thereafter,
you waited for since 2014.
Sir.
And then you only approached in 2025.
Sir, that's exactly, this is the reason this honorable court wanted me to look into few judgments. I have seen that. In sum and substance, those judgments, I am carrying the judgments. The judgment says a writ court has its discretion subject to the condition that I have to establish a case saying that I was prevented or there was no reason of justification.
A proper explanation.
Absolutely.
To be offered.
Absolutely.
Correct.
Absolutely, sir. So in my case, what had happened in 2014, allotment was made to me. I had paid 1 lakh. and I received a letter saying that remaining 15.7 lakhs you pay. Before I could pay that, I received a letter from LIC saying that, look, the government has raised an objection saying that ROR should be with me. Hence, I can only go for registration. So please wait. They gave me an option saying that either you wait till we do the job, or if you want, you can take back your money. I say, no, I will not take back your money. Let it be with that. Thereafter, another confusion came again at the government level, whether these 10 acres piece of land was a forest land. If it is a forest land, then everything had to go. The entire structure had to be demolished. That went on between LIC as well as government. LIC filed a writ petition in this honorable court and all. This went on and on and on. In 2024, that was finally clarified by the government that, okay, you can go ahead. It doesn't fall in this category. Also, they have earned the ROR in between. So possibly there was no option for me because at that point of time, I being a small man, I could not have challenged the government decision whether it falls in forest category or not. Or I should not have been forced by LIC also to challenge the main notification because my fate is intertwined with others. So it's only in 2024 an occasion arose. They had to give it to me. In 2025, what they have done, instead of giving those flats to us, we allottees.
Where is the order dated 19/12/2014?
Dated?
19/12/2014.
60, page 60.
Page?
60, 60. Of the petition.
Yeah.
Of the writ appeal, yes, sir.
Well, I know 60.
My Lord Gautam,
Yes.
can I read it?
Yes, I'm a very fast reader.
Sir.
Yes.
Sir, for a moment, kindly see the one page.
It's not providing any option. The letter is very categorical that your allotment is cancelled.
Sir, for a moment, kindly see page 50.
Is very clear that it is cancelled.
Sir, kindly see the letter of 19 June 2014. That is at page 57.
That is the subsequent letter.
Correct.
Of 19 December 2014.
Correct.
And conveying a very clear decision of the LIC that your allotment is cancelled. And the amount will be refunded to you by any amount.
Absolutely. Absolutely. Now, the reasons attributed for cancellation is only one reason.
Maybe that the government has raised that it is constructed on a forest, which you say that in 2024 in the writ petition it was the specific stand of the government that it is not on a forest land.
Correct, sir.
I understood, but once the cancellation has already been done in 2014, what you were doing for nearly 11 years.
Sir, I did. Kindly see page 61.
The order of
Kindly see page 61. I did. Kindly see page 61.
The order.
No, I didn't challenge.
So
I didn't challenge. What I said is, look, this is only for this reason, the government notification and all. So possibly this is not the only option available to you. I'll still continue.
It's not a case for question of option, sir.
Sir.
That it means that by this letter of 19/12/2014, an option is given either to keep you continue with your amount, if considered in future, we will take care of that, or you can take it refund. It is a clear and very categorical letter that your allotment is cancelled.
You're right, sir. But the cancellation reason.
You could have challenged this order of cancellation immediately. At least I gave you 1969 column 1 SSC as well.
Yes, sir.
That though there is no period of limitation provided for filing an application under Article 226. But if a suit of such nature can be filed
And if there is a period of limitation provided for institution of the suit, then that period would be taken into consideration.
Sir, kindly consider my position.
That's a why judge.
Absolutely. I bow down with this observation, but kindly appreciate my situation. Sir, even in 2014, if I had come to this honorable court, what would have happened? Whether this court would have rewritten the law?
Then it will open a more Pandora box because of my civility, my civil background. A decision is taken by a court.
Yes.
That your the letter of cancellation is justified because they have said that it is a forest land. The government has also indicated it is a forest
this
land.
is an order.
And I'm telling you, suppose the writ petition is filed.
Correct.
And it is dismissed.
Correct.
On that ground, it's a forest land.
Correct.
After 15 years or 10 years, in another proceeding, a court held that no, it is not a forest land.
Correct.
What would be the remedy of the person who has suffered that order?
Everything will
Can he
be
go for a review? Can he file an appeal thereafter? Or can he go for another proceedings saying that this finding has now been declared to be incorrect?
Sir, these are
I'm asking you, tell me the law.
Sir, the law is very clear. If an eclipse, whether by government or
that what I will do at that point of time, because it's a forest land, it's a forest land. But I'm telling you a more extreme case.
Absolutely correct, sir. Absolutely correct. But the point what I wish this honorable court to appreciate is a small citizen cannot be forced with rounds of
different law. The law can be differently interpreted in relation to a poor man, in relation to a common man, or in relation to a rich man?
Not at all. I'm not saying that. Having said that, all that I'm saying, all that I'm saying it with great respect. At times, a hyper-technical view can be taken. I am before a fountain of justice. I am in the court jurisdiction.
To be respected.
Now, sir, kindly see one position. Insofar as the impugned order, what is before you is concerned, with the same set of facts, one single judge of this honorable court decides in one way, the other single judge decides in another
depends
way.
upon the factual aspect. There may be a situation that somebody has already approached the court. We do not know.
No, I'm not on that.
Somebody may have
I'm not on
approached the
that.
court timely. His matter was pending. Now, after the decision has come, he has taken that stand. It all depends upon a fact.
Sir, all that I'm saying is, on that particular day, had I approached the court, that would have been like fighting against a wall.
No, sir. Why?
Because when LIC stand is very clear, I have nothing against you, but for this government notification. That is what their stand is. That is what their stand was, is on that date. Is on that date, that is what their stand was. And look at the injustice what they have done. What happened in 2014, 75 flats were subjected to this kind of a situation. Now in the e-auction, they are only going for 70 flats. Also, what my lord is my lord is referring to, and I'll tell this honorable, I'll try telling this honorable court how I am perfectly fitting into this. This is, I'm reading this 53. This is the judgment my lord wanted me to read. Oh, my lords wanted me to read. Para 53 sums up the whole thing, sir. Yes. Para 53, the relevant considerations in determining whether delay or latches should be put against the person who approaches the 53, sir. 53.
Okay. Yes.
The relevant considerations in determining whether delay or latches should be put against the person who approaches the writ court under Article 226 of the Constitution is now well settled. They are: 1, there is no inviolable rule of law that whenever there is a delay, a court must necessarily refuse to entertain the petition. It is a rule of practice based on sound and proper exercise of discretion, and each case must be dealt with its own set of facts. Number 2, the principle on which court refuses relief on the ground of laches and delay is that the rights accrued to others by the delay in filing the petition should not be disturbed unless there is a reasonable explanation for the delay, because court should not harm innocent parties if their rights had emerged by the delay on the part of the petitioners. This is where I need to tell this honorable court that no third party rights has been created because of the delay. Sir, the third part. The satisfactory way of explaining delay in making an application under 226 is for the petitioner to show that he had been seeking relief elsewhere in a manner provided by law. If he runs after a remedy not provided in the statute or statutory rules, it is not
14
correct
of the limitation.
Correct. Today I am also before an equity court. This Article 14 also comes into picture.
14 principle of the limitation act.
Correct. Principles I appreciate. It is not desirable for the High Court to condone the delay. It is immaterial what the petitioner chooses to believe in this regard to the remedy. No hard and fast rule can be laid out in this regard. Every case I'll have to decide. So what my lord is saying and what I am saying, we are not differing with each other. All that I am saying, my situations and my exceptions are definitely warranting the justice to prevail. Correct? Why I am saying that?
Let us then start. What is the justice? We'll accept this.
Sir. Correct, sir. In this matter, what is the justice?
Justice is that you should be allotted.
No, not. I'm also an officer of this honorable court. When the question is in the realm of law, I'm not representing any particular petitioner.
Yes.
As an officer of court, what I'm saying, what is the justice? Justice is, the single judge has very well clarified in the subsequent single judge. Justice is, LIC was given a piece of land saying that please construct houses and give it to the policy holders subject to certain rules, right? The whole idea is to not to make money. Why LIC was given? The first phase happened sometime in 2005 or something. 192 flats were given on those principles by draw of lots. Thereafter, the second thing happened, second phase. We are talking about the 228 flats in second phase. That happened in sometime in 2011. Out of the 228 flats, minus 75 flats again were given on those principles on draw of lots. And there was a particular price. Today, in relation to the 75 plots also, 5 plots were given in accordance with the single judge's order. In relation to only 70, they are now saying it will go for an auction. Meaning thereby, LIC has assumed as if it is a developer meant to make profits. That is not the whole idea for which this land was given to them. This is what I wanted to tell. Independent of this technical question. Insofar as this technical question is concerned, look, this court, I repeat, is a fountain of justice. I am before an equity court. And a small man, why I am referring to small man or poor man is, look at the government's holistic decision. Government entertained a suspicion in its mind, maybe this land is in forest category, right? And that clarification, government only had to do And why should I fight? As a responsible citizen, if government says that, it could have been possible. I'm under a duty to believe in government's decisions and all. So today, if it had gone under Forest Act, then I would not have approached this honorable court, nor I had gone to LIC. Today, look at the situation. Between 2014 and 2025, for about 11 years, there was an eclipse, a sacrosanct eclipse, if I may use this word. Today, the eclipse is gone. So my legitimate expectation again arose. And look at the similarly circumstanced persons, the other set of people who are also similarly circumstanced. They had approached this honorable court. This other single judge of this honorable court, what he said in his observation, saying the same thing. What I'm saying, yes, my lord is correct that I had an option to come in 2014, which I did not. Maybe for the responsible counsel, on that date I repeated, I got on that advice I acted on. But today the fact is, till date, and this judgment what I read, it is very clear. In the meantime, because of my delay or perceived laches, if a third party right got created, today that is not the situation. I have specifically moved an application saying that this number of flats are yet to be allotted and all. So keeping all this into consideration, I have no doubt in my mind that this honorable court appreciates this entire position. And now I am at the mercy or discretion of this honorable court. I have a case, A, to say that these delays cannot be attributable to me. 2, to say that particularly when two single judges pass orders diametrically opposite to each other, and I am in.
Where are two orders diametrically opposite?
Yes, sir. This is one is the impugned order, and the other order my colleague had given you on that. Repeat the order, sir. Satyavan Kumar Panda. Yes, sir. Correct. So on principle, what had happened in the impugned order, the learned.
I got it.
Yes. In the impugned order, the learned judge
has said the delay in this, he has gone into the merit and decided.
Not into the delay. No.
He has gone on merit and decided it on merit.
Correct.
Absolutely not on
correct.
delay. That means
Absolutely
he is not
correct.
gone on delay.
Now, in the impugned order, what he said, no rights has accrued onto me. That is the reason writ petition will not lie. That is the impugned order says.
Correct.
Here the other judge went into the merits and said that it's not a question of right or wrong and that he has done it. So today the question of limitation what my lord is raising, definitely I'm under an obligation to answer and accept what I stated before you. Except that I have no other submissions on that.
So that's all. Thank you. No other submissions?
Sir, on limitation, there is no other submission. Sir, on facts, if you allow me, I have.
You have already said that so far as the merit is concerned, the learned judge in this particular case has held that you have got you have accrued a legally enforceable right. Everything has been done in this case.
Yes.
It's no difficulty. We are accepting.
Only one additional point is when 75 flats fell in this category, in the e-auction, they have done it only for 70 flats.
Yes.
There is no reason. And unfortunately, while passing the impugned order, learned judge had no material before him to comment on escalation of price and all. There was no reply on record.
Right.
The observations of the learned single judge has no substance to that.
Right. So,
yes, sir.
Can we dictate?
Yes, please.
The
record should be called for and the matter be deferred.
No.
There is nothing, not even a whisper.
And this
LIC did not assist the court in any way.
we filed a written note of submission in all those cases, and that has been taken into consideration by the Honorable Single Judge.
Where is it?
Yes, it is there, reflected in the order itself. May kindly see you, please. Kindly see the order.
Those are submissions.
What submission?
Those are submissions.
The matter was
no reply
at the
filed.
stage of admission only.
There was no reply filed in this matter.
No reply. No.
Where
He was
is
given
it?
to file and the reply.
If my lords can kindly see paragraph 8 onwards, everything is unsubstantiated.
And because he was insisting, because we are going to hold the e-auction, he was insisting matter should be immediately heard.
No. The trial court the order, the lawyer should not interrupt, should not interfere. They will take a note of the
Item number 8.
So, with your permission, only one supplement to mention. So far, whatever my lords is dictating, that is not taken note of prayer before the single judge. My prayer was nothing to do with this aspect. Of course, this aspect is inseparably linked. Prayer was I challenged the e-auction.
I will go through it.
That
Item number 8.
In below. Towards of challenging the my period. When challenging the order of Honorable Single Judge, page 240, relevant pages 240 minutes. The batch of writ petition has been decided. Dispose of a common order. This the batch of writ petitions has been disposed of by common order limits. It was in reflect that those are all architect and degree holder engineers. The architect and degree holders. But my case, the petitioners in Bachelor of Planning Millers. But that was not taken into consideration. When the fact is the advertisement was issued for the post of planning assistant, and the importance was given to the diploma holder architect, we have the planning assistant, the eligible candidates, applied for the challenging the writ petition, and the Honorable Single Judge has granted mental protection. I applied, and the Honorable Single Judge has passed an order that till the disposal of writ petition, the results will not be declared. Now, my lord, the final decide if you face 240 millers, the Honorable Single Judge hold all the petitioners connected batch of writ petitions is the architect degree holders.
Yes, what do you say?
So, if you look at the cadre rule, the rule for recruitment to the post of planning officer, but the rule prescribes the minimum qualification as diploma in architecture.
Yes.
Now, advertisement was issued pursuant to that. Now, the present petitioners, they have bachelor in planning. Even they don't have the bachelor in architect also. They have bachelor in planning. As such, they are not eligible to apply in terms of the provisions contemplated under the rules. So what the judgment?
Where is the judgment of this 226 W226?
The page 240 relevant page.
And WA number 62.
Yes, WPC number 35790. First WA number 1509 of 2025.
No, your judgment in the first matter says that the same has already been settled by this court in the judgment
Yes,
of
Lord.
312, the WPC 226 of 24 hours, and affirmed in WA 62 of 25.
That I have annexed 241 in my writ appeal minutes. That was separate contest, my lord. The other principles, it was
No, I'm just asking where
My
is
lord, I'm sorry, my lord. The T241 lord page.
Are you a diploma holder or a degree holder?
So, my lord, bachelor in planning, my lords.
Degree holder.
Well, it's degree holder, yes.
What has been decided ultimately in that?
Well, it's ultimately, last part, my lords, 281. It was the 11 pages, 280.
So the court has held that once the qualification is diploma, the higher degree holders, they do not have a right to participate. Yes. In paragraph 26 of the said judgment. Then where is the WA? That is the answer 15.
Yes. Yes. That was confirmed.
So now, if that is the reference in the field, tell us that why we should take a dissenting view.
Lakshmi, yes. Below the page 41, the post for planning assistant. Below
can we go against that? We have to follow that particular judgment of the court that is binding on us.
Well, that is the what I'm saying.
You are admittedly a bachelor degree holder.
Yes.
So if the judgment says that the bachelor degree holders are not entitled to participate, then what?
Because the advertisement was issued in particularly emphasized to the diploma in architect students. Now, my lord, I am the bachelor in planning, my lord. The post is for bachelor in planning, my lord, the planning assistant.
That was challenged if they do not find any incongruity in this.
So that is, my lord, the higher qualification question. It does not arise here, my lord. Let's not
You are a degree holder.
So, degree holder, my lord. Now, my lord, they are architect planning, where their post is great. Assistant.
Nothing has been done, then what that mean?
Let me kindly for a moment. Architect in architect.
You are saying that it should be a bachelor in architecture.
Yes.
And not the bachelor in planning.
No, that I am not saying, my lord.
Then what you are
The
saying?
post is for, my lord, the planning assistant.
Correct.
They should have filled up those who have come out from the planning, my lord, the bachelor in planning post.
Correct.
Now, my lord, the advertisement is the post is bachelor planning that has been diploma in architect, my lord.
They must have. So now are you challenging that it should not be after participation?
No, let's see, before participating, I challenge, my lord.
What?
No, that in particular the advertisement I have challenged.
Show us the writ petition filed by you where
that I seeking a permission from this honorable court to
where is the writ petition?
Writ petition.
Your writ petition is 35790.
Yes. Yes, my lord. The page that, my lord, the annexure 10 344.
So is this your prayer? Should I take it that you have asked for a direction upon the opposite parties to accept the hard copy application of the petitioners pursuant to the advertisement dated 14/11/22 and allow them to participate in the recruitment and selection process? That's your prayer? You have not challenged that.
Subsequently, I have filed the amendment application.
I am looking at the amended.
Yes, my lord, Lordship, kindly for a moment. Amendment application.
No. Amended copy is there. Where?
No, my lord, that is not amended copy, my lord. That, my lord, it was read petition. Subsequently, after the filing the read petition,
that is the subsequent.
The amendment has not been allowed, my lord. That amendment has not been allowed. It still is pending, my lord. It's pending in the during course of hearing, my lord, pending. Then, my lord, during pendency of the amendment application, it was been decided, my lord.
What can be done?
So that was not taken into consideration at all.
Then it has been rejected.
And Melody, since 2012, Melody 29/12/2022 bills, the learned single judge has granted permission to Melody participate in the said process, and results are be kept in result. If that is not can declare, the till disposal, the writ petition, that has been ordered. Then subsequently it has been disposed of.
True, that is what.
So now, my lord,
you
my
stay subject to the result of the writ petition. So the outcome of the writ petition is a dismissal.
So lordship may kindly for more. The only question, my lord, only question, the post is for the planning assistant, my lord.
You have not made out a case of such nature, sir. If you go by your writ petition, which stands, your application for amendment was not allowed. Can you take that advantage?
That that is pending, then subsequently it wasn't.
I'm just looking at it.
Yes. So lordship may kindly for a moment. The page 219. That amendment application.
I do not find from ground A to G that you have also challenged that particular aspect.
Well, there also I want to amendment page 226. That's why for a moment, please. That amendment application, that's schedule C.
I'm just asking you a question. The amendment application was filed during the pendency of the execution. It has not been allowed.
No.
And the writ petition is distance. That means what? That the amendment application is
automatically
expenses. When you are challenging the order, can you not challenge that order as well that implied rejection? I am just thinking in the light of section 105 of the Code of Procedure.
That was not pleading.
No. That permits an appellant to challenge any interlocutory order passed in the suit at the time of filing an appeal against the judgment and a decree. So you could have challenged the order as well. You have not done so. Can you raise this plea?
That's
the only point I was.
Lordship is absolutely correct because the amendment application has not been allowed, pending, and subsequently it was now, my lord, what my predicament follows, all the students have suffered, my lord, because what I'm saying, all the participants have been suffered, my lord. Why, my lord? The overseas, my lord, since 2022, they have already applied.
And when your services really are satisfied, what?
That the lordship is absolutely correct. But your lordship think that the post is for planning assistant. They are emphasized to the
not applicant. Not made out a case in the writ petition. What you are arguing? Can you be permitted to argue this point? You have not taken this plea in your writ petition.
I'm not interested because that is not been there. But
then what to do?
So lordship only follows the. I can pray willows only and nothing beyond that.
What to argue them?
No. Lordship, for a moment, I lordship, my lord. So lordship is know everything because
we are not against you. You think over what to argue and come back.
So we give you a lead and you don't understand the lead.
I'll.
Do whatever you can do. Take the advice of the seniors, they will tell you what to do.
Sister can advise.
Yes. What?
Gain some experience, sir.
That's right. I'll go on Miller's theory of influence. Because the only point, if your lordship may allow me permit, only one point is.
Not pleading.
That is lordship.
Harping on that, think about it, what to do.
So only one point, my lord.
Want to hear from your mouth.
Only one point. Honorable single judges had not been.
We are not exercising the advisory jurisdiction. So is your.
The splitting is not there, so
maybe you have to nurture in your way.
plus rate petition is all pleadings is
So
not there.
what to
That
be
should have
done?
understood. Understood, Lordship.
Just when understood, then next case what? But should we keep this matter after vacation? Or we pass an order here?
Only Lordship may kindly. Plus, if your Lordship will allow me some other day, then I will recover it.
Yeah, allowing me, go.
Okay.
1 week after.
Item number 9.
Great.
This is a case where I have filed an case and I for
Why is the contested matter? Why you are just last day of the
disclosure factor. Here the direction has to be given for extension of time. Because there is a decision of the Honorable Court that any decision about taken.
1 minute.
On the basis of problem of Supreme Court guidelines.
Yes.
Supreme Court has said that scheduled date cannot be.
Yes, yes, my lord. Now the date has been extended up to 31st of October that I have got the letter. Only I have come to the direction for a direction to observe that the schedule which was given in 2019, that is there in the judgment. So we want to take a change to that we will allow for renewal of NOCs, deficiencies to be given to us complete. For renewal of NOC for 7 days may be given because already up to 31st of October, the time has been extended for admission. As previously also in this case also, your direction.
You are part of the.
That's what I'm giving it. Last phase number, how did you find it? There shall be no departure in any case from the said guideline, time schedule, without the leave of the court. Now the guideline we are going to go away from it. So that's why we want a leave.
As the schedule, the date and time, the date prescribed by the government, dated 22/10/2019, for the issuance of the NOC and grant of supervision.
Yes, please.
So you have to, because the government has already fixed the time. Yes. Now, and this is affirmed by the Supreme Court.
Yes, ma'am. That admission
The
is.
Supreme Court says that this time gap you cannot extend.
My lord, the schedule for getting the applications, we are only changing.
But the admission is date fixed, that was the 30th of September. Now it is been extended to 31st of October. So that's why we have come for this, for accommodating 52 institutions, those who are not complied with. That's why what they.
But who has extended the time?
Nursing Council, madam. This is the letter. Indian Nursing Council has extended the time of admission.
Which was the other side?
My learned senior is appearing for the Director of Medical Education and Training. So far as Appellant's Council is.
That is appellate.
Appellate Council is not
The
there.
Nursing Institute.
Yes.
Have you not given them a copy?
Yes, I have given them a copy, but no.
Whether the supplementary additional list has come.
You have to serve him a copy.
I have served a copy, madam. They have not come because last occasion also when they down.
Then you send a notice to the institute itself. Serve the copy on the institute. If the lawyer who represented the institute is not appearing, then you have to serve him a copy. Serve him a copy. This application surveys upon the appellate.
Item number 10.
Please appearing.
Lord, may it please your lordships, my lord. Item number 10, my lord, I beg to appear, my lord, on behalf of the petitioner.
Yes.
My lord, if your lordship sees my lord's last order, my lord, this is the matter, my lord, with respect to the supply of ultrasound machines having 4 bores. My lord, if your lordship sees the last order of your lordship, my lord, your lordship wanted them to file, my lord, if I may place it before your lordship. They said, my lord, that they have their para-wise comments ready. And my lord, they wanted just a few days time to, my lord, file the.
Not yet, we will file in.
They have filed nothing. And then what happened? They have started issuing work orders.
You are appearing for
5, number.
Yeah.
4.
You have not filed your.
No, you also want the government to file first. Because I was not called upon to file. All the documents are there.
Lord, nobody has filed anything.
He was appearing for the medical corporation. Who? Mr. Samir Kumar Mishra. He was earlier appearing for the medical corporation. Now he is not in the finance. So state has to.
Last week, if I remember, the honorable Advocate General, he requested that he should file the return. And he was absent on that day. Actually.
Lord, the problem is that they have not filed their documents, and just before the vacation, Lord, they started issuing work orders. This is where my problem is, and this is where I'm saying, Lord, that there is malafide. Because now, my lord, what happens is at the fag end, if they start issuing work orders and if the machines are being supplied, then my, lord, writ petition becomes infructuous.
So I'll show. Executed, our execution of the agreement has been executed, supply started now.
That's exactly what I'm saying, Lord. At that point of time, there was nothing.
And then
on 12th of August, there was nothing.
Make 3 pieces.
Since past August, it was not.
On that day, it's the solution. Sorry, says that he has received the paralyzed comment and given immediately filed
Yes.
counter affidavits. Then why he is not filing?
He's no more in the.
Well, that's because they don't have an answer to our.
Again. And this was in the month of August.
Lord kindly stops them from issuing the work orders and hears it out below, there is no problem. Fag end of the vacation below, they started issuing work orders. Now, just below, just a few days back, they've started. That's why, my lord, I mentioned it before your lordship below that this is the malafide which is going on. Because they know, my lord, the vacation intervenes and I will not be able to do anything. And, my lord, if they get my writ petition infructuous.
Purchase order for 1 each.
Before the order. They have already, they issued prior to the order.
Prior to the.
No, my lord, at that point of time, they said nothing.
It was.
On 12th of August, your lordship was not informed.
First of August, the order is, the work order is of 1st of August.
My lord, on 12th of August, they did not inform your lordship about that. They did not.
Whatever we.
But now, my lord, kindly sees, if I'm not mistaken, probably just 1 or 2, my lord, were issued, my lord, at that point of time. Kindly, my lord, if I'm not mistaken, because I'm not there physically, my lord, because of this list problem, if I'm not mistaken, maximum 1 or 2 or to the extent 3. But, my lord, only 3 or 4 days back, they started issuing.
Yes, in the
ultrasound machine, 4 bores.
What is the challenge which they are making?
The challenge is on the basis of a document saying that the requirement was there from Indian, no country outside India.
No.
Country
I'll tell you a lot. With a lot of respect to my learned senior friend, with a lot of respect to my learned senior friend, that is not my challenge. I'm sorry, that's not my challenge.
But that document is absolutely no relevance for the present case.
It's completely, it's with a lot of respect to my learned senior friend, that's not correct. My challenge is that they had to have an US FDA certification. That's the tender requirement. This US FDA certification, is given to one factory, to a particular factory. The US FDA certification which they have given, is a factory in Shanghai. And they have declared, that this US FDA certification is a factory in Pune. So Pune factory, from where they are going to supply, doesn't have a US FDA certification. On the other hand, we have entire certifications on our end. One, what my learned senior friend says is not my subject of challenge at all. The tender. He's probably not available today, that's why I was being.
Yet some strategies waiting for the.
On the last occasion also, I was there. Your lordship would remember, my lord. There was some problem because of the urgency, my lord, only nothing more than that.
You are Mr. Somi Kumar Mishra.
Yes.
You submitted on the last occasion that you have received the paralyzed comments and you will be filing or counter.
Post after that, the corporation called me and I was told that the state government will conduct the cases. I should not appear in the cases, and that is how in one property case I recused myself. Here also, I think my associate also gave a statement before lordship on the previous date that we are not in a position to file because we have been relieved of the responsibility, my lord. The MD himself personally called me and told that on the day of listing in the morning, she calls me and tells me that the government council should conduct the case. I should not appear. So I was bound on, my lord. There are 3 cases they had engaged me. One of the cases, your lordship remembers, that was disposed of by your lordship. There also in the morning, I received a call that I should not appear. I recused myself. The government council appeared, your lordship disposed of that case. This also a case and one more case is there. Same with the instruction, my lord. So I have not been appearing in these cases, my lord. And they have specifically instructed me not to appear. My lord, that is the difficulty and my name may be deleted.
is not allowed, that otherwise commented on everything must be there. Why you are not filing?
Subject to correction, I think they have been briefed also as far as the analysis.
Why you not filing your
We should file.
Not filing. When you will file?
Only on 12/8, the matter was last listed. Thereafter, there was some.
No, I think it is much before that. In other case, they told me specifically not to appear in any of the case, and the MD was very desperate to ask me not to appear.
No, 12/8 you have appeared.
In all this doldrum, my lord, the only person who suffers is me.
When he is told not, then he has a parawise comment. It must have also the same thing. Why you did not file your the counter? Why you will not file?
If the authorities instructions available.
Not expected. The person who appeared, who knows of the entire things, and who on whose prayer we have directed the process affidavit, and then the subsequent decision.
There is a malafide in the entire process.
And the person who is now interested is just standing in the way that I do not know. I have to file. Why these things are happening? Then, if the conscious decision is taken, let him face the music of it. We will not permit. Not permit.
If it is tomorrow, I'll just take instruction.
No instruction is
not there. Yes.
No instruction is required. What he says is correct. No instruction is required. If such a drastic decision was taken, then the promptness must be shown.
There is no written instruction.
He has come with a helpless situation, in a helpless situation.
Somebody personally rings him up, he received the process without any written instructions. And you.
If he has chosen, then he should show the promptness. Why he will not show his promptness?
On that day, actually, my friend was asking time. Next day, he'll file the affidavit and documents.
Absolutely.
Okay. What he has passed through.
Yes, I understand. That is what I say. And all the documents were there. It's all there on record.
No.
Based on respect, you. Because Sunny's confidence, nobody can.
Sir.
Because of your.
What my lord wants to say, in fact, he is my guru. And he is also.
It does not give a good taste.
The Annex 7 is the only document they rely on, which doesn't form part of the tender document. The only thing they have.
Milord, it's with a lot of respect to my learned senior friend, that's not the only document. If they show, Milord, that they have a USFDA document, I have got nothing to say. They don't have a USFDA certification, and the tender requirement is that they will have to have a USFDA certification from the Milord factory from where they are going to prepare.
Correct. Annex 7. You got it from our website and file it actually. Their own.
Yes, we've done so.
What is the condition which is there in the tender document that these machines must conform to what specification?
Yes.
Milord, kindly have a look at
this document they are showing. But if you are
Milord, kindly have a look at page 55.
This document.
Which are time permission. I'm extremely sorry for the information.
No. We have taken an.
I'll show you, Lordship.
Yes.
Below the tender document starts at page 55. Kindly looks to below the one.
I just two minutes I'll take.
May I show your lordship? My learned senior friend would defend it. Allow me, I am the petitioner, my lord. Allow me to show your lordship.
But last time it was pointed out, therefore I'm showing. Last time, Annex 7 was brought to your lordship notice.
My lord, I'll show your lordship what is the requirement. I'll show your lordship that. Before your lordship, take your lordship to the Annex 7.
What are the requirements?
Kindly turns to my lord, page 55, and then the conditions, my lord, your lordship will find at page 71. Page 71.
Yes.
Lord, kindly have a look at, if your lordship sees, below the authorized distributors, we both of us are authorized distributors, below. Kindly it looks to number 5 at page 72, Roman 5. The authorized distributor, my lords, kindly go.
Valid ISO certificate, valid IS.
Yes, BIS
certificate of the manufacturer.
kindly stops at USFDA. That's the problem. That is the problem, my lord, area. And then sees as per section 7, the technical specification. Kindly turns to that page at 110. And it will, your lordship will find that at 117, it starts from 110, comes to 117.
Yes.
Lordship will see number 1. The quoted model should be USFDA. Lord, then in bracket kindly sees 510K CFG and EUCE certified. EUCE below, there is no problem. My learned senior friends clients have that. With respect to USFDA now, my lord, kindly turns to page 732. 732. In 700 and, my lord, if lordship has got 732, my lord.
Thirty-two.
732, my lord. This is their tender document. This is what they have, my lord, supplied. And kindly sees the F10K number, 510K number. The 510K number, my lord, it is Food and Drug Administration to Philips Ultrasound, REK 182857. Lordship has got that plot. My lords have got that plot.
Yes.
May I ask this question to my lord, this is their 510K number. This 510K number, my lord, is given to a factory in Shanghai. And they have told your lordship, my lord, that they are going to supply from a factory in Pune. So the Pune factory doesn't have a USFDA certification.
That's all.
This is a very, my lord.
Let us hear Mr. Mishra then.
Yes, yes.
Let him clarify.
My lord.
Yes.
Okay, look at page 732. Read to check 117. 117, product and manufacture quality standard 1, 2, 3, 4.
What is the problem, sir? If you take me to these papers. There's a very problem with the system. When you take 117 and take us to 700, it's very difficult to go to 700. Yes, 700.
Lordship takes up liquid text, it's way better.
17 reduced 732.
Yes.
At USFD.
Yes.
9th November.
Yes.
It qualifies all the requirements.
Yes, yes. So he is talking about key number.
Sir.
Key number.
A182857.
Yes.
At the top, that's a reference.
Yes, sir.
At page 732.
117, A1.
Yes, 117, A1.
Yes.
Correct.
The quoted model.
Yes, must be US FDA.
Yes. 510 CFG and UC certified.
Correct.
We have got the certificate.
Where is that?
Yes.
That shows the matter ends.
Yes. Sir. So kindly turn to page 820.
Yes.
This is the form MD, website 820.
Yes.
License, manufacture, sale and distribution, Class C, Class D medical device.
Correct.
Philips India Limited, so and so, so and so. Then Maharashtra Police, so and so. Name of qualification, detail of device, model number, so and so. If you also look at the intended use of facility, series ultrasound system, diabetes ultrasound image flow, so and so, following indications, so and so. Then sir, turn to page 81.
821.
821.
Yes.
Philips India Limited confirms our product, affiliated 7 making Make in India, concerned with Healthcare Innovative Center in Pune from Chakan Factory, so and so, made in India, affiliated 70 diabetes ultrasound, local content 36%, UD5 reference trade item so and so, number is there.
Correct.
This is Pune manufacturer.
True. But what about the US FDA number?
732 page?
Yes. 732, which talks about something different.
No, it said we received your section 510.
Now he says that this number pertains to a factory which is there in Shanghai.
Yes.
And not in Pune.
Not Pune, sir.
He is saying that this number which you are quoting, this is the US FDA number.
Yes.
Which is K1828857. This from the net document which you are referring, that shows that it is given to a company at Shanghai.
Yes, my lord, that's at page.
What is that page number?
My learned senior friend probably. That is 835. Kindly look to 833 and then 835.
835.
833 and then 835. What my learned senior friend showed your lordship, my lord, was a CODSCA, which is an equivalent to an Indian thing, not the US FDA. It needs to take instruction on that. Kindly see K18257 at 833.
It is definitely belonging to a Philips. Belonging to a Philips company, no difficulty. But it says that the registered establishment is Philips Ultrasound Shanghai Company Limited.
Shanghai.
No. Shanghai Company is no way the document, no way concerned. Annex 7 years.
Yes.
Annex 7 is not part of the document, not part of our tender document. They have obtained it from the...
No. What they say is that it is definitely not the part of your document. Right. But what the document you have submitted is 732.
Yes.
In 732, there is a reference of a particular number.
Yes.
And then once they found the veracity of this reference number, they found that this reference number is given to a Philips Ultrasound Shanghai Company Limited. That means the Shanghai means manufacturing out of the country, not make in India.
It is make in India, sir.
That is what you are saying.
Yes.
There is one fundamental thing, my lord, which your lordship kindly considers, is this US FDA thing is given to the manufacturing unit, not to the company. My learned senior friend needs to, my lord, with a lot of respect, he needs to understand that. US FDA is given... I'm sorry, my lord.
Mr. Mishra, 833.
832, Your Lordship.
33.
33.
The
Yes.
pre-market submission number.
Yes.
The last but 3. That is K 182857.
K8828557.
Yes, this is the same number you will find in your letter dated 732 at 732. Same number.
That is your document which you
This is your document. 732.
732.
Yes. On the left hand side,
reference.
Reference is K182857.
The
K182857.
Right.
Now again, 833 is the same.
You come to just above that two lines above. Establishment name.
Yes. Same number.
Same number is manufacturer. Where? Establishment name. Just 2 lines above.
Philips India.
Yes.
That is what Mr. Chatterjee says, that it is not manufacturing India which is requirement. I think that is the proposition which.
This is a product. This number will we do this. This document itself is not correct document to collect with us. They have just filed this.
Oh, is there any other document where you can show that this may be a wrong information?
I just wanted to show their own document is exactly the same thing. I'll just show one thing. That document actually.
My document.
Show us. That is the downloaded from the website. Don't worry. Sometimes the veracity is also very questionable.
Sir.
We are very, very conscious about it. Don't worry.
Sir. That's just one thing.
Show us.
I just wanted to show yourself their own document is identical to this. But they have also filed. This is the same
It's not
document.
about us.
Yeah.
Not this answer 7.
Yes, that is what we are referring to. 833.
That's volume 1, I think.
Our document is probably not under challenge, but even I have no problems on that. I can show that.
It's 462. Page 462, I think. This is 462. Can you look at 462?
That is K 192157. That's different numbers. K
No. We have given my learned senior friend is probably
462
is not given correct instructions. Our
Mr. Chatterjee, when he is placing, let him place his case. You have already placed.
Very good. I'm sorry.
Can you look at 462? This is their own document.
Yes.
This document they have applied also. If you also looks at 732 document and 462 document,
yes,
both are identical.
No, this number varies. K192157.
K192157.
Yes. It is not
It's different.
your number.
Your number is different. Your number is K18. Your number is 182857.
So these are two separate devices.
Probably you could not get. What he is trying to make out a case that when the tender condition requires a particular certification to be appended, and those must be manufactured within the country.
Yes.
These are the twin conditions. Then you have to show that you have the requisite eligibility qualification in this regard. You have shown your qualification by submitting the document. From the document, he says that what you have disclosed is not correct. You have said that this particular equipment is manufactured at Pune, and it is a make in India.
Right.
They say that the certificate number which you disclosed in your document discloses that this certificate is issued to a company or establishment at Shanghai in China. So it cannot be presumed to have been manufactured in India, or it is a make in India concept. This is a small point he is raising. If you can show that this downloaded copy is absolutely wrong, show us with the other document. No difficulty. He will be thrown out. He will not be here.
But our Pune certificate is also there. Register certificate is there.
That's his own certification.
Sir, Mr. What is you are for?
The petitioner.
Petitioner.
I'm with Mr. Challenge.
Both of the devices.
Ponder upon the thing. I think your junior has not properly assisted you.
So actually what has happened, these volumes actually try to confuse me. I'll just, can I just...
I think he has not pointed out to you that what is the zone of dispute. I believe so.
Last question to select 72 techniques pointed. You are not examined. You are not examined in these lines.
Whatever I have examined just now only.
No, this is...
And if the Lordship would have a glance to page 71, it doesn't say the manufacturers should be from India. It says that they submit manufacturer authorization, the authorized distributors, page 71, if your Lordship would kindly see. It says the author 5.2.2 says authorized distributors are eligible to participate in the bid provided they submit manufacturer's authorization directly from the original equipment manufacturer, its Indian subsidiary as per format T7. That is what it doesn't say that the manufacturer should be from India. And as I understand, my lord, not gone through in detail, but I can say, my lord, if the Shanghai, if the Philips Corporation that is at Shanghai, yes, and they have the distributors have procured from the Pune, and it is manufactured at Shanghai, which has the...
No, while finalizing the tender, you must have verified this.
That is not...
That is where we want.
Only...
You are putting that.
No, what he's saying is cannot be. T7. One for 59. What's enough? T7, 156. It is only a certification from the manufacturer.
So 831 and 32, if you also looks at, these are later. Fourth row. It says, we Philips India having registered office also at Rajarhat, Kolkata, and having manufacturing facility globally along with India. Philips India Limited is a subsidiary company of India of Royal Philips Netherlands.
Sir, can you produce the this certification T7 in your whatever you have?
On the 17th page.
No. 156.
No, 100. No. This is 156.
It is a format. What is that certification you have received? Do you have that? Which you have, you must have given to be
medical corporation.
Come to page 71 first. Come to page 71 first.
Well,
page 71. If you come,
page 71.
The authorized distributor it says that they submit.
71.
Yes. Roman 1.
Yes.
They submit manufacturer's authorization form
directly
from the original equipment manufacturer.
Yes.
/ its Indian subsidiary.
Sir.
Both.
Yes.
Either of them. Okay. As per format T7.
Right.
Says format T7 is page 117. 117 if you come.
This is 156.
So 497.
Sorry, 156. I stand corrected. 156. Come. I stand corrected. 156.
That's the format.
So this is the format. Manufacturers. And this is to be submitted in the letterhead of the manufacturer.
Yes, ma'am.
Okay. So it may be an importer or a distributor who can definitely bid it.
Yes.
So it does not say where the registered office is. Then why the word Make in India was introduced in your letter also? The word Make in India, when you reflect, then what was the reason for reflection?
The reason being, if our 497, if our sim looks at, page 497. Form 17, T7. 497, the 497 is given.
Yes. Yes, sir.
Format T7 reference, that reference is there.
That's true. No, I understand. There's no difficulty.
Right.
Probably you could not get it because Mr. Das has suddenly took a point that if the conditions does not envisage that it has to be a manufactured, it has to be manufactured in India.
Here actually in the present case,
It says anybody, yes, the distributor or he can apply, not, there is no condition of manufacturing the gadget in India.
it is mentioned in 117 that you read it just now.
Yes.
Product and manufacturer quality standard mentioned quoted model should be US FDA UC certified.
Where is the condition that it has to be manufactured in India? This is what I am really asking for. Mr. Mr. Chatterjee is raising this issue. Mr. Das has said there is no stipulation that it has to be manufactured in India.
Restriction, if you can look at, there is a restriction, in fact.
Milan, my issue was that from wherever he manufactures, that unit must have the US FDA certification.
Oh. But
that unit must have the US FDA.
My friend is there, can you also permit her to clarify that document? No, I think.
Your Lordships, I'm assisting Mr. Mishra in this matter. If your Lordships may kindly see page 117.
Yes, allow us to clarify that document.
He is assisting you and...
I'm assisting your Lordships, Mr. Mishra. I'm from the local council's office. I'll just assist on this point so that there is clarification. Page 117, your Lordships, there are the requirements for the tender, which says product and manufacturer quality standards.
Madam, we have gone through it. We just wanted, where do I get it that it has to be manufactured in India?
If Lordship see para 1.1, it only says that the quoted model.
Oh, I understand. Madam, you have quoted and you have emphasized on Make in India in your application. I just wanted from your senior that what was the reason?
Your Lordships, what the other side is trying to show is that the USFD certificate is not a proper one for the factory. In fact, it is not for the...
It is what is there. Anyhow.
Yes, Lordship, the requirement is only for the model to be USFD certified. Our model is USFD certified, which is available.
I understand when it says at page 156, not at page 156. I have to tackle different arguing councils. Page 71, it says that you have to submit a manufactured authorization form in T7. There is a prescribed format at page 71.
Right, your Lordships. The only few
requirements. So T7, that talks about the manufacturer's certification. And format is given. If it is correct, then it is a manufacturer is a Shanghai company. The manufacturer is at a Shanghai.
Manufacturer is in India, your Lordships. There are only few requirements. This has got a little complicated. Therefore, just to clarify the position, I'm trying to just read down
But if
what
it's
are.
complicated, then it requires hearing.
It is not complicated, Your Lordship. It's very simple. It's very straightforward. Page 117 gives the
Anyhow,
requirement.
Mr. Mishra, your junior is there, then you sit with him, with her, and get the clarification done.
Tomorrow.
Definitely, we are keeping this matter tomorrow. We can't go on in this way. Your junior will come on a virtual mode and wanted to assist. You are not being consulted. There is no.
That reference to the number your lordship says, I'll just clarify that for you.
You just.
Why is it required to be manufactured in India also? I'll clarify.
No, that's true. That is what we wanted. He has highlighted two things. One thing is a manufacturer's certification,
right.
T7. If the manufacturer is at Shanghai, whether he has given or his subsidiary can also give,
right.
All these things you come with that, justified, there is no difficulty.
Put out those things in lordship balance. This was our hard before.
Yes.
And your lordship very rightly indicated.
And the senior of your age who can appear in person, the juniors are on a virtual mode. Just imagine.
Tomorrow is from drink.
Yes.
Item 11.
Unnecessarily going here and there, it makes no sense. He admits that he is no longer in the, he has been instructed not to appear on behalf of the opposite party number 2 in the instant matter.
Great for me.
Yes. Who is appearing?
Item 11, similar cases, that was filed by Mr. Misra.
No,
he is not there.
Huh? Spillover. Yes, spillover.
Item 12 also. Item 12 also. Item not 11 and 12 both.
Correct.
Item 30.
My lord, we are recapitulate the earlier days. It is about the eviction matter, my lord. My lord, kindly have a glance to the refused orders at case 70.
Yes. This is under the Odisha public premises.
Yes, my lord. Yes, my lord.
So section 4 notice was given.
Yes, my lord.
Section 4.
They received notice, my lord. The outside. My lord, what?
Outside means.
The written.
So no, you are for the appellant.
Yes, my lord. My lord, I am only agreed by this 5 and 6 because there was a statement from the learned counsel who was appearing before the honorable single judge that they will vacate the quarter by 50.
Correct.
My lord, before going to my lord, if my lord give me only one chance. My lord, if I may satisfy, then
You may have a very good case on law. Let us see. How can you wriggle out of this admission?
One judgment that day I shown before your lordship. Only my submission before your lordship is that the statement which has been made before
Without any instruction.
it is unequivocal because when it is unequivocal and in the absence of the opposite parties, then it must be the honorable single judge to find out whether there is any instruction from the client.
Is it whether they have to make like an investigating agencies, they have to run a parallel investigating agencies to find. Then the veracity, the authenticity, the genuinity of the submission advanced before the bench from the bar. Then every time we have to suspect the bar that whatever they submit, I have a suspicion whether they are correct or they are not. When a member of the bar appears and he submits, it is presumed that he is submitting on instruction received from the client. Unless the client comes forward and contradicts, then here it has not been contradicted by your client. Then shall we go? That means without hearing him, we are accepting the allegations made against him. Do you know the consequences for that? If the court holds that he could not have made submissions without instruction, the client may also take steps. And that he will be penalized, or maybe he is put into a position without being heard.
So, my lord, actually no notice was sent on that day. That's why they did not.
What is the notice? No, your submission was, that was your submission, madam. Say that you please give me a time, I'm willing to vacate. That means the learned advocate must have said on instruction. Now you are saying that there was no instruction given by my client that he would vacate. That means you are belying the statement made by the member of the bar. Can you do it at the appellate stage? Your client has not come forward and shown an affidavit. Then, then we will give him an opportunity. He will come and say whether there was instruction or not. We can't, sir. Once you have admitted, then you cannot challenge the order. Sir.
I got that.
Sorry.
On the request of my learned friend, the last occasion, there was a observation to give undertaking.
How much time will you permit?
30th October,
30th October. Here. File an undertaking.
My lord, this is actually since
Undertaking duly affirmed by your client before the oath of commissioner.
my lord, the predicament is that
No predicament. We will not go by this. No, you'll have to affirm it. See how he has. This is not an undertaking.
So because only one day was given, only 24 hours. We could have only gathered this through because it was at Joda Mine.
I do not know how an undertaking is given in the court. Nobody knows. It must be an affidavit.
My lord, may I suggest me? My lord, I may say clients to it is by oath and they will submit before before 5th May.
And if he violates, submitted before the authority, then what we will do?
Premises
How?
October.
How? How? You should talk law. Then how?
Because it is in the order itself that he had submitted.
Can't be so you will come and say that they cannot take the law in their own hand. And if it is a affidavit filed before the court, then the court will definitely take steps if he violates the order. No matter. Sorry. File it by tomorrow, then it's all right. Otherwise, we are not going to say anything. The predicament is 5th. I understand. You'll have to secure it by tomorrow.
Joda, my lord, 300 kilometers away.
No, how you meant get it?
My lord, only through scanned.
No, you can't. They have to come. They have to come and affirm.
Yes, sir.
Item 14.
No, just take it out, but I just keep it. If he comes with the, just keep it. If he comes with undertaking, that's all. Otherwise, it will go with.
Item 14.
This matter was before a lordship day for yesterday. Mr. Mishra appeared for authorities and sought copies, 2 copies. We gave 2 copies and also online. This is the position so far as his instructions concerned. But to tell your lordships, the matter is all thought about. All over the country, all the major courts, they have berths which they operate on the private public partnership. We also operate all over the country, my lord. We're one of the major players all over the country. In every port, we have the berths we operate. Here, there was a contract for a berth for a container, exclusive container berth. Is an issue before the lordships. No reasons have been given. The reasons, my lord, is only on the basis of understanding or presumption or no reasons have been given by that. They have said that you are only disqualified. But it's a twofold. First is qualification. The second is for bid. And the qualification stage, they have rejected. But if you also ask me that what could be the reason, because I overqualify in every other terms, but that only could be, Lord, if you also turn to page 150. 150 is a government policy. Lord, turn
150.
But they have not filed any affidavit counter, but still I am telling you notice that page 150.
Yes.
Look,
yes.
It's a government policy of India policy, which is followed by all major port trusts. That if your lordship is policy, the second part, Lord, if there is only one private terminal berth operator in a port for a specific cargo, the operator of that berth or his associates shall not be allowed to bid for the next terminal berth for heading the same cargo in the same port. Lord, this I have read many times. Specific cargo, the same port, the same berth, and your lordships get it, the Roman for the next page. What is specific cargo? Specific cargo means containers, but it's a very high value of more than 500 crores. And at this stage, they have rejected on qualification, not on the bid. Anything has not done. Specific cargo means containers, liquid bulk, dry bulk, multi-purpose or other delicate. Now the question before our lordships is simple. Paradip port does not have a specified container berth. It did not have. That's on record. And that's so philosophy. Not having a container berth, they had a multi-purpose berth where I am my sister concern is operating. Out of 18, I'm one of them. That I am operating a multi-purpose berth where they said, including containers. That means, my lord, since Paradip port did not have a container berth, as a sort of a makeshift arrangement, they allowed the multi-purpose berth of mine to have a container facilities in part for which a very minuscule portion was handled as a container berth. Now they hold when they first time established the exclusive container berth having exclusive features. Not every container berth has exclusive features. They say that since I have part of that container berth, this government policy will stand against me.
That you will not be permitted to participate in the bid.
That is that. Since I have submitted the law, they never had a container berth. They had a multi-purpose berth. I am a multi-purpose berth.
Since the permission includes the container, so that's why.
Yes, includes. It includes because at that particular moment, for exigencies of service, since there was no container berth, as a makeshift they are.
Where you will get it?
Given the reasons, I'm only presuming the reason that could
No,
not
no.
be reason.
The reason has not been assigned.
No reason.
Where it is?
Page 66, sir. Page 66. I just out of your lordship can put it out of my best of my ability, find out and details and some page 66, sir. Name of the applicant. First three are the qualified. List of applicant not qualified. I have the name not see. Next part. I am not qualified. No reasons given.
Annexure 1, page 66.
66. If lordship is. Yes. So, my lord, the question.
Yes, you are number 2.
Yes.
But reason has not been assigned.
No reason. No reason. If you also ask me that, I just prodded my reasons what could, because I'm overqualified in every other aspect. It's not a question of that. I just thought some amount of people also can say murmuring in the auditor gossips of Paradip Port authorities because no reason given. I had to come before.
Who is for the Paradip?
There.
What is the reason for? What is the reason for disqualification?
That's my kind permission. The tender was quoted and the petitioner along with 4 others participated. Page 67.
No, that is what is there. 5% participated.
Kindly see page 67, annexure 2.
Yes.
There, my lord, the technical evaluation for the tender was there, and it is reflected in the lord rejection. You are informed that your bid for the above tender has been rejected during technical evaluation by the duly constituted committee for the reasons not fulfilling the TQC.
What is this
and
TQC?
The clarification or feedback by pre-qualification criteria. That is 2.62. I will come to your lordship. I will come to.
Yes.
In case any clarification or feedback,
you may contact the tender in writing.
Nothing has been written.
Whatever.
And so far,
I can understand. Then what is the reason?
May not say kindly. Yes, I am just commenting. Since my lord, yesterday we got some instructions because the reason my lord wanted to know I have to maintain the transparency and to maintain. Can you see the government of India, my lord, is not a party here because the government of India, due to my camouflage manner of the private operators 2010.
This is not the policy you were referring.
Yes. 2010, the government of India come with this policy.
Yes.
That because it is the interpretation of government of India.
Correct.
Government of India is not the party.
Yes.
But the tender condition which have been the author of the tender, they are to satisfy their lordship whether qualified or any colonial exercise power or the things done or not.
So please, he is referring to the definition of the specific cargo.
This is the government of India policy. And kindly see page 3. Page 3. I am not without taking your lordship burden. I just put 2.26 the prevention for the private sector monopoly in major routes.
Yes.
I am a formula to place.
Yes.
Ministry of Ports, Shipping and Waterways, Government of India, by this later numbers, once dated 2nd August 2010, has issued the policy to be followed by all major ports while awarding the projects to private parties through public-private partnership PPP route so as to avoid private sector's monopoly in the major ports. The aforesaid policy or any other applicable policies shall apply mutatis mutandis to this binding process, and the authorities are entitled to disqualify any bidder in accordance with the aforementioned policy. My lord, kindly turn to page 4. My instruction which I received at the J.M. Boxy Ports Logistics Private Limited. As for Appendix 8, policy for preventing private sector monopoly in major ports, for the request for...
So his presumptions or his perception appears to be correct. Then he is correct.
And
you are taking, you are taking a particular route to throw him out. What he says is that if I am operating the berth for multi-purposes or something, and when the specific cargo definitions makes a distinction between a container and the multi-purpose cargo, then in that event, even if he is at the time of granting it, it says container, but there was no facility, there was no occasion to handle the container cargo there, then in that event, how can you reject it?
These are kindly, I'll just come to Lord. So far the clause.
That's only one sentence or more. 170 is their document is the answer. 170, sir. Page 170.
Yes.
That is similar. Currently, this fact what I am saying, Lord, is they say. Sir, kindly see page 170. And the court master to be.
Blood cell.
Page 170.
It has been the clause 2.26.
I'm just saying that they are
satisfy Lordship.
Your Lordship will satisfy.
The author, the language has to interpret it by the text.
Yes, yes, we will, definitely.
Kindly, sir, see, currently, if I page 170, the multi-purpose berth at Paradip Port, that's me, is engaged in handling container berth to a limited extent in the fiscal or export boiler company. Although major ports like Haldia, etc., dedicated container and handling container has not prioritized the development of exclusive container handling terminals. That's what I'm saying, my lord. That's what they're saying. That I have a multiple.
One of the humble submission to state the Indian government may clarify because why
there is not a clarification in that.
If that is interpreting the language, that is
the difficulty is that you have put an embargo that if somebody is already operating in a berth for a similar category of the cargo, then in that event, he is prevented from participating in any other bid of the same
cargo in the same port.
In the same port. Now, obviously, 2.26 is to avoid any monopolist things to come. Monopoly has to be removed. Otherwise, one is taking the entire junk. No problem. You can put. Now the question is whether you can put this impunity in them from participating in the tender when admittedly in your port there is no container berth facility. If you grant a license, then in that event, can you say is a same category of the cargo or in the same port? Now you have introduced the container facilities at the berth. They wanted to participate, if I correctly understood is there. They wanted to participate in the container category. For first time introducing this container.
No, but yes, that so far the 2.62, 2.26, it is not, it is my condition. It is being done by the government of India.
To what?
So, government of India
then do one thing, sir. You could have incorporated that any operator in this particular port, if she is debarred from participating in the bid for that port. You have not. You have not. You say that if he is already handling one specified cargo or a special category of cargo, then he cannot participate in the same category of cargo in the same port.
For this time, not next time. For this time.
No.
See the language. In this regard, it has been noted that at Paradip Port, containers are being handled by only one private terminal. That is Paradip International Cargo. My senior client is PICTL, which is associated to JM Baxi Ports and Logistics.
Show me that you have the container facility at your port. Please tell me. The document which is relying on at page 170, it says the second paragraph. Although the major ports like Haldia, Kolkata in the north and Visakhapatnam, Krishnapatnam, Kutupalli, Chennai in the south have dedicated container handling terminals and handle substantial containers cargo. Paradip Port has not prioritized the development of exclusive container handling terminals or a berthing facility. So you do not have.
Yes, that aspect,
don't have
for that
container.
aspect, my lord,
In
with
military
great
purpose,
with
they
great
allow
respect to my
container.
lord's query, my lord's view, my lord, the tendering authority, who is the lord, the clause has been inserted in the tender document. The document, the author of the the contract, but they are blood stipulated. Your lordship has the power to examine to blood. So far, the interpretation. To that extent, I will take instruction. I have blood to that expect. I have taken
Then
instruction.
don't proceed. Don't proceed further.
But I will take instruction.
Don't proceed
There are
further.
only 4 categories. Your lordship says, yes, let them not proceed with this.
But that back. Because is a public contract.
Let me
And
Otherwise, you may be
the language of the contract, language of has to be interpreted by the tendering authority.
We are holding or opining prima facie from an undisputed documents.
But
what are the documents is a tender document, what you say and what it conveys. So if we can go for it, then you in the meantime you take instruction. We are not relying on any other document which is a disputed one.
My lord, it is not my condition to government of India and government is not the party here. Let a copy be sought on government of the minister.
Sir, we are not, the things are, sir.
Because government of India.
The government of India has framed a policy.
My lord.
Nobody, if anybody challenges the policy, then the government of India has to be heard. If somebody comes forward and say that this is what I meant with the policy, and if something is meant by somebody else, then what is the necessity of the establishment of a court?
Millard, I would like
is the court will go for an interpretative one. What do you mean by that language?
Good. In fact, they are
citing one judgment.
That is what is appearing.
The owner and employee project having authorized documents and best person to understand the applicable language. Let them come with the Millard language interpretation. Then Millard will find a decision.
Sir, if the court does not find any ambiguity in ascertaining the meaning, even if somebody has weirdly accepted, will the court?
Yesterday, I got the limited instruction.
But that does not mean. That does not mean. You have correctly done. You have said.
Yes.
And this is what we have to accept.
And
it.
they have also mentioned in the read bits of paragraph 34 to 39. They knew that they are not, but they want to Millard demonstrate in such a way. They want to develop interpreting this language and they want to take a handle and interpreting this way. So the interpretation to be done by tendering authority, my lord, with great respect, this 2.62 clause, let them come with a proper counter, my lord, because now in the preliminary stage, I will file a counter because they have stated.
You file a counter, we don't mind, but if you proceed to decide the tender, then what would remain at the time when you file a counter?
Millard,
tell me.
There are other.
Either you give an undertaking that you will not proceed with the tender any further. No difficulty. You take your counter, file it. We don't mind.
With respect, there is a clause that in case of the clarification feedback, they can contact the tendering committee authority. They have not filed a letter. They have not approached whether your bid will be accepted or not, or any kind of ambiguity or any kind of clarification. You can file a petition. You can file a letter requesting the Parliament authority that, sir, these are the things. Let me clarify. But they have not done directly come to this honorable court and now interpreting the clause. And law settlement Afghan infrastructure when an Nagpur case is led that the interpretation author has to decide and no interim order may be granted. This is the judgment I am citing. Hold this matter.
What? Let me. Sorry, I was concentrating on the paper. Sorry. What proposition of law? Sorry, that's my mistake. That's my mistake.
Jagdish Mandal versus State of
Please give it.
That is something different.
Yes,
Yes.
power
but
of
it's-
judicial review is there. Lordship may intervene. Your Lordship may can.
We have also delivered a judgment, the power of judicial review.
But only Lordship.
And we have also delivered a judgment that what is the scope of the inner matter as well.
But since Millard,
Huh? Where is that, you were referring those pages?
Sir, 150 is the policy.
Just,
Yes. 150 is the policy.
yes.
And
Paragraph 2,
Where it's same, where is kind of a restriction.
government policy.
No, where is a,
Annex to 13.
this is in the policy itself.
Yes, same specifics.
Yes.
Specific cargo.
Is there any stipulation of this policy in this tender document?
This is 1-2.
One.
Well, it is stipulated for the bid next time, next terminal. That is the Millard language of the central government.
Next is policy.
2.26.
2.26.
Yes, this is what he is referring.
Yes, that's admitted.
The 2010 policy.
Yes, there is no
2nd
difference.
August 2010.
And Millard, the ground brought by senior that without an asking reason, that is there in the tender document, page 102, plus 2.7, may kindly be referred.
What? Sorry.
2.7, the right to accept or reject any all other applications bids by the Millard tendering authority. This is
2
the
point?
tender doc, page 102. No, that is why you are alleging that without asking reason.
Oh, I think you did not mention, I have already tagged this. And
Sorry.
also,
Grateful.
I scored.
Your lordship wanted that.
But also is telling anything.
2.7.1, I have already underscored it.
Grateful.
There's no difficulty, sir.
Your lordship wanting
So
that.
unbridled power, how far it can.
Your lordship wanted that page where I mentioned about that multipurpose in 170. 170 is the page.
Starts at 152 and 170. Starts at
Yes, sir, that is what I said.
Sir, 170, sir. Currently, the multi-purpose berth, I'm reading it very slowly, sir. The multi-purpose berth at Paradip Port is engaged in handling container cargo to a limited. That means I am a multi-purpose berth. I am being asked to handle a container in a very limited extent because it's not a container berth. Thereafter, it says, my lord, although major ports like have dedicated container berths, Paradip doesn't have. So they want to have. There where I have been excluded, though I am a multi-purpose. As you lordship knows, government policy, no quarrel with the policy. If I am a multi-purpose, I am barred from multi-purpose. If I am a container, I am barred from container. I am a multi-purpose, I can't be barred from container only because I have been asked to handle in absence of any other, because there is no other facility, I have been asked to without being a container.
Yes.
Why not kindly see their amendments para 34 to 39. They knew that they are not qualified. That's why, my lord,
the instant writ petition is taken up, is filed, sealing the decision of the authority in declaring the petitioner as a declaring the I think in a interlocutory stage, everything has been. It's because of him. He had lot of confusion. So I know those principles of law which is applicable.